Before the Honorable, the Justices of the Appeals Court, now sitting at Larson, Huen, and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for the 6 cases we'll be hearing this morning. To my right and your left is Justice Vuono. To my left and your right is Justice Greg Massing. Today's panel session is the last of the June sitting for the Appeals Court, and with that, the last time that I'll be sitting on panel as a justice of this court before my retirement at the end of the summer. Justice Vuono and Justice Massing have asked me if they could offer a few thoughts about that, and so I will turn things over to Justice Vuono.
Make sure I have this. Can you all hear me? No, you can't. Hold on. Can you hear me now? All right. Good morning. In keeping with a special tradition of the Appeals Court, commencement of oral arguments will be slightly delayed so that I and Justice Gregory Massing can pay tribute to Chief Justice Mark Green on the occasion of his last sitting. After 23 years of service on the Appeals Court, 16 years as an Associate Justice, and the last almost 7 years as Chief Justice, Mark Green will be retiring, as he just mentioned, at the end of the summer and starting a new chapter in his life. Let me just take a moment to thank everyone for being here, all the Appeals Court staff, our fellow justices. I understand a number of Supreme Judicial Court justices are here. I see at least 3 of them who have already served with Mark Green on this bench a number of times. That would be Justices Kafker, Wendland, and Wallahojian. I see also Justice Dewar here. Welcome to you, and I'm not going to name everybody else individually because I need to get to the most important person in the courtroom. I want to acknowledge Karen Green, Justice Chief. By far the most important person in the Chief's life. She is a former judge of the Superior Court, and for those of you who don't know, the Chief met his future wife, Karen, at Harvard Law School. I didn't ask him, but I'm confident that he would agree with me when I say that the best decision he ever made was to marry Karen Green. The two have an enviable relationship, a true partnership built on love and respect, and a shared interest in achieving justice through the judicial branch of the government. They have 2 sons and 3 grandchildren, ranging from 15 months to 3.5 years old, and I have it on very good authority that the Chief will be spending a lot of his time with them in the very near future, and our loss will be their gain. I mentioned that the Chief attended Harvard Law School. He graduated cum laude in 1982. Thereafter, he had an illustrious career as a lawyer, practicing transactional real estate law, and then serving as general counsel for a number of large banks. In 1997, he was appointed to the Massachusetts Land Court, where he served until his appointment to this court in 2001. His time on the Land Court was short-lived in comparison to his time here with the Appeals Court, but his knowledge of that court and the issues, both routine and novel, with which that court grapples daily, is broad and deep. All the justices on this court can attest to that, as each of us has sought his counsel in cases involving questions of ownership or proper use of a parcel of land. As the Chief has eloquently said many a time, I still like to play in the dirt. Kidding aside, the Chief is extraordinarily generous with his time. In the 18 years I have known him as a colleague, never once did he ignore a request for advice on a case or on any other subject for that matter. And even as Chief, with all the additional responsibilities that that job entails, he is quick to volunteer for an extra sitting if the volume of cases requires one, especially if that keeps our numbers up, very important, and also to sit in for a colleague who is ill or otherwise unavailable. It may sound boring to some to be described as reliable, but in the context of the court's work, reliability is a virtue, and the Chief is exceedingly reliable, and we have all appreciated how much we can depend upon you. The Chief's accomplishments are many. Justice Massing will provide you with some more specific details about them. And for my part, I just want to note the following three things. First, if our primary job as justices of this court is to settle disputes, and as the Chief recently remarked, to get it right, and to do so in a way that the parties understand, then, Chief, your legacy is not only sound, but rich. One need only peruse the green books behind me, and you will find numerous decisions, each one characteristically cogent and to the point. The Chief is a superb writer, with an uncanny ability to marshal complicated facts and explain legal intricacies with clarity. I can't tell you how many decisions he's wrote. I didn't count them, but I believe Justice Massing did, and he may be able to provide some information to you on that. However, I can tell you that the Chief has written on every subject arising from all the trial court departments and all the administrative agencies of the Commonwealth. Second, as Chief, Mark Green has been and still is the leader of our court, and that is a huge responsibility. His leadership was tested when the COVID-19 pandemic hit. Without doubt, there was no one better equipped to handle the crisis and create a safe environment in which we could all continue our work. He is the epitome of innovation and adaptability. When the world turned upside down, Mark just rolled up his sleeves, and in the face of adversity, he was always one step ahead. I think he might have been one step ahead of the CDC, because I do recall learning about the levels of the virus in the wastewater in the Boston area and beyond on almost a daily basis. Third and lastly, I want to say that this is truly a bittersweet moment. It's bitter because the citizens of the Commonwealth will no longer be the direct beneficiaries of your experience and dedication to the rule of law. Bitter also because we will not have the pleasure of your company on a daily basis. But I said bittersweet, and there is a sweetness here as well. The sweetness at the bottom of the pie of retirement, as many have said, is that the Chief will have more time to pursue other activities. He is an avid reader, an adventurous traveler, pretty good cook, but most importantly, he will have more time to spend with his family. I know Karen, you and your sons and their spouses and your grandchildren are thrilled by that prospect. So, Chief, on behalf of the entire appeals court, I want to thank you for your collegiality and your service. And on a personal note, I want to thank you for your wisdom, the many kindnesses you have shown me, both big and small, and for your unwavering friendship. And now, I call upon Justice Massing to say a few words.
Thank you, Justice Vuono, and it's my great honor and privilege to be sitting here together with you and, of course, with Chief Justice Green on his last day on the bench. From my perspective here, I was able to locate one more dignitary that we missed. It's retired SJC Justice Bob Cordy is there in the back. Welcome, Justice Cordy.
Welcome.
So in preparing for today, I looked back to see how many times that I argued a case when Justice Green was on the panel. I was an appellate ADA in the Essex County DA's office for the first 4 years of his tenure here. And I gotta say, I haven't been as nervous since then as I am right now, speaking. But so it turns out that even though I felt like I knew Justice Green well, and I would see him at bar events, and he was always very affable and greeted me like he knew me, I only appeared before him twice. The first one it resulted in a published opinion, Commonwealth versus DeRusso, 60 Mass App 235 in 2003. I wouldn't expect you to remember that case because during the Chief's tenure on the court, he's authored over 250 published opinions. That's not to mention 1,190 Rule 128 and Rule 23 decisions. Thank you, Monique Duarte, who has been indispensable to the Chief and to all of us for probably, I think, longer than even the Chief has been on the court, for those figures. And if you consider that those written cases only represent about a third of the cases that he sat on, that means he's sat on almost 4,500 cases on the appeals court over his tenure. The only other time I appeared in front of you was It happened to be my last court appearance ever as an attorney. It was February of 2007, and it was the only time I ever argued a case for the defendant. Actually, Scott Kafka was the panel chief on that one, and Mitch Sikora was probably one of his very first arguments. I lost that appeal. That's not why I stopped doing appellate work, but... So in the interest of time, I'm not going to be able to discuss in depth something that I actually spent a lot of time studying, getting ready for this. The assignment that Chief Justice Green took on before he was chief in 2003 when he was requested by the SJC to chair the study commission on trial transcripts. And as many of you in the room will remember, in those days, it could take years for transcripts to be prepared, and that meant a criminal defendant sitting in jail awaiting appeal for years and years before they even got it even heard. And it was really an embarrassment to the courts, and an intractable problem because it involved lots of layers of management and labor and so forth. So in just 6 months, the chief chaired this committee, and they came up with a comprehensive study of practices throughout the country and practices here and recommendations for what they could do. It was actually the study committee's report is available online if you want to read it. It's very detailed and thorough. It's pure Mark Green, and he was later tasked as the head of a working group to implement those changes. Suffice to say that today, and in fact, for the 10 years I've been on this court, trial transcripts has not been an issue at all. Much to to keep the wheels of justice turning, thanks to the chief's hard work on that, and it was a lot of work. The chief was also the leader in bringing the judiciary into the 21st century in another way, electronic filing and paperless practice. The appeals court, under his leadership, was at the forefront of e-filing in the Commonwealth, showing the way for the rest of the judiciary to follow. For many years, until he was appointed as chief, he chaired the appellate court's IT steering committee to oversee and implement improvements in information systems. In 2016, he asked me to join the committee as the only other appeals court justice. If you know the chief, you're not going to be surprised when I tell you that the committee was tightly organized around a successive series of 3-year strategic plans, each broken up into 10 categories with immediate and long-term goals prioritized under each category. When I joined the committee, the appeals court was already receiving briefs electronically, but the SJC was still requiring 18 paper copies of the briefs to be filed. And so the electronic practices that we take for granted today also took a lot of work to implement, and also we can thank the chief for saving a whole lot of trees. Interestingly, there were 2 items on the strategic plan that received little attention year after year. One of them was under the category of system enhancements. It was to replace our sort of dated remote application with VPN technology so that briefs and appendices and transcripts could be delivered to justices' iPads quickly, and also so that all members of the court could get access to our internal drives from outside. Justice Wendland was actually instrumental in pushing us to get that done. But it lagged, as did another item at the very bottom of the report under access to justice. There's a little item about exploring the use of video technology. And these are things that we kind of didn't, they weren't immediate needs, and we didn't, year after year, they just stayed at the bottom of the list. You see where I'm going with this, of course. In March 2020, there was suddenly an urgent need to get content to our iPads in a remote, contactless way, for every staff member to have remote access to the internal network, and for a video conferencing platform for oral arguments. There was simply nobody in the world more qualified and prepared to lead the appeals court in this transition than our sitting chief was. And under his leadership, we made an almost seamless, quick shift to remote work during the pandemic. And in fact, seeing how well that it worked, the chief has since then been a champion of our hybrid staffing policy that permits staff to work remotely as much as 3 days a week. If I've focused too much on technology, it's partly because the chief does love this stuff. And he really will get into the weeds, often using complicated technical technology and speaking in complete paragraphs sometimes. He and I recently had a conversation about how good it is that judges in Massachusetts are appointed rather than elected. And we were musing about how we would do if we had to run for office. And the chief said it might be a challenge for him because, quote, I don't speak in sound bites, which is true, and ironically, it's a terrific sound bite. if I had more time, and we do have some cases to get to, I'd spend a lot more time talking about two other committees that the chief stood up on the appeals court. They weren't here. We didn't have them before. Under his leadership, we have a committee on diversity, equity, and inclusion, and we have a workplace engagement committee. And these committees were both created in the interest of making the appeals court more supportive and respectful of the people who work here and the attorneys and the members of the public who come to the courthouse seeking justice. And I have to say this, the chief is also the only person I've ever come in contact with since I've lived on the East Coast who is familiar with the song Billy the Mountain by Frank Zappa. In short, Chief, it's been a privilege to have you as a leader and a friend during the past 10 years, during my past 10 years on the court, and I'm grateful for this one last chance to work together on some cases. And if I may take the liberty of speaking on behalf of Justice Vuono and myself, and all those assembled here, we thank you very much for your service to the Commonwealth.
Well, thank you both. As Justice Milkey mentioned last week at a similar occasion, at the appeals court we allow no rebuttal, so I will not attempt to correct some of what you've just heard, at least not at this moment. I do understand that we, as I said before, do have 6 cases to hear, but that not all of you, in fact, I think not most of you, are here for those cases. So I will allow a little bit of time. We'll stay on the bench, but for those who wish to leave before I call the first case, now is your opportunity. Thank you all for coming.
But once you get into it, as that,
Sure.
once you start to get into it. I ended up
I'm
using,
sitting over here.
I ended up using the paper. Like it was just I couldn't.
I saw that. I saw that.
Well, the other risk
Glad
is
to
that
have backup,
if the screen goes dark because you're reading too slow.
Right.
Hoping to put Karen on the spot, but she is the star.
No, absolutely.
She's not waiting to hear all the arguments.
She gave it the office.
Yeah.
Right. So the first case on our list for hearing this morning is the first of our 3 criminal cases. It's case number 2023 P1052, the Commonwealth versus Adam J. Leac. Since we had that other ceremony, I did not have the opportunity to go over the ground rules. You're, of course, frequent flyers. You're familiar with them, but just for the record, each side of the V has 15 minutes to argue. If more than one attorney will be arguing on either side, please let us know ahead of time how you'll be dividing your time, and there is no rebuttal. If you reach the end of your time before you reach the end of your argument, you need not continue. If you reach the end of your argument before you reach the end of your time, if you reach the end of your argument before you reach the end of your time, you needn't continue. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains. Ms. Jellison, you may begin.
Chief Justice Green, may it please the court, Eva Jellison on behalf of Adam Leac. I'd like to use my time to address 3 of my issues today, the first being the spontaneous utterance, the second, the manslaughter instruction, and the third, the chalk. Of course, other questions are welcome. The jury did not hear that in response to an officer's question of what happened, the victim, Mr. Correa, said, "bed frame." This was a spontaneous utterance. Counsel asked for it to be admitted on that basis. I think the recent SJC case Brum suggests that experiencing a serious injury is an exciting event. This communication between Mr. Correa and the officer happened shortly after. And
actually, could you be a little more specific on what the problem is here? Because you said that the jury didn't hear bed frame, but they did hear bed frame.
They heard bed frame.
And in fact, in closing argument, defense counsel argues the victim said bed frame. Is that what he hit his head against? So exactly how did the bed frame not get in? What's the problem?
So the bed frame's absolutely, and your recitation is correct. The problem for me is that the jury did not hear that Mr. Correa said bed frame in response to what happened. And that seems very powerful to me.
Was there a question what happened and he said bed frame? Is that what?
Yes, what happened? What happened to you? What happened? Bed frame. So that's different to me, and especially the specific testimony is actually really important here. So I'm going to read you what the officer said about bed frame. What he said about bed frame was he had mumbled something about a backpack and about a bed frame, but nothing that identified anybody or really what had happened to me. And that's at transcript 369. So not only is the jury not hearing that bed frame is a response to what happened, they're also getting the opinion of the officer that bed frame didn't really have anything to do with anything, that it's this mumbling that's going on. And the judge instructed the jury that they could only use bed frame for Mr. Correa's state of mind. So the jury really wasn't able to use bed frame to say that that was what Mr. Correa was saying happened to him. That's what he, that's...
There's also evidence that the victim was disoriented, didn't even know where he was, didn't know who he was. I mean, there was
Yes.
There was a significant amount of confusion and impairment. And the judge, in the exercise of discretion, made the determination that the statements were not sufficiently reliable, whatever they were not sufficiently reliable to have any meaning, and other than to illustrate that he was in a befuddled condition, which is how he allowed them to be used.
Yeah, so I have a couple responses to that. Number one, the judge really didn't exercise his discretion in this matter because what he did was rely on another trial where he wasn't the judge and how the evidence was used in that trial. He says this on the record, and we don't actually have the reasoning of the other judge on the record, so we don't know what the reasoning is. So for me, I don't believe that he really exercised his discretion. And he didn't bring up the reliability issue. The Commonwealth brings that up in its response. And what I say to that is, look to this court's case in Tang, where they describe that the most important thing about spontaneous utterances is that they meet the spontaneous utterance test. There may be a little question of competence, but the rules for witness competency in Massachusetts, and I really go into this in my reply, but the rules for witness competency in Massachusetts are very loose. We don't have an age limit.
Competency, I think, is a label in a box that's helpful in thinking about this, but the underpinnings of the hearsay exception for spontaneous utterance really relate to indicia of reliability. That's the whole reason why we have that exception.
Right, and that's exactly what Tang says. It says that
when we have a statement that is made in circumstances that in the assessment and evaluation by the judge do not carry indicia of reliability suitable to allow them in evidence, isn't that something that we ought to defer to?
Right, and if the judge had made that ruling, I would say that it would that your comments would carry more weight in this decision, but he didn't make that ruling. And if you look to other cases, I really think that you'd be changing the law here. If you look to other cases like Commonwealth versus Don, like Commonwealth versus Harrison, those are cases where people were shot in the head and then made these spontaneous utterances. And just because they said the defendant's name, I don't know why it should come in and this should not. And also, as to the disorientation which you mentioned, the officer testified specifically that he answered this question. He was able to answer, when they asked him, is Lance Correa your name? He was able to answer that question, and that he became more disoriented after that. So I understand that he was experiencing some disorientation, but he became more disoriented after he gave these answers. And if you look to the case law, I cited Harrison, Don, Napolitano, Joyner. These are all cases where someone had a very serious head injury, either, like I said, 2 gunshot wounds, and then the second 2 are blunt force
But it's
injuries.
not simply the nature of the injury, it's the effect of the injury on the declarant, right? Someone can have a very serious injury and still have full use of their mental function at the time. That was not the circumstance of this case.
Right, and it wasn't the circumstance in Don either. The SJC rejected an argument that because the person had been shot in the head and because there was medical testimony that said that the person couldn't have been responding to the questions, the SJC rejected that.
That was in a case where the judge allowed it in, and they said
Yes.
that was not an abuse of discretion.
That's right.
But the SJC might just as readily have upheld a refusal of the judge in that case to admit it as not an abuse of discretion, right?
I can't say what the SJC would have done, but
Neither can I.
I do point the court to the Tang case, because in that case, what they say is that reliability is really based on the spontaneous utterance test. Was there an exciting event, and was the person still under that excitement? And that we're not looking to kind of other questions of reliability. That is the reliability test. So if you're looking to that, you don't have to be attending perfectly to all of the questions. You don't have to have not been injured. There's the Harrison case, the person, I believe, passed out, or no, it wasn't the Harrison case. I apologize. I can't remember the name of the case, but there was a case where someone was gravely injured. They had been slashed and were bleeding quite heavily, and a spontaneous utterance was admitted, and they passed out soon after. So, there have been several cases in the Commonwealth where someone is gravely injured, and the touchstone is the spontaneous utterance test for reliability. So because of that, this should have been admitted. Do you have further questions on that issue?
No, I anticipate that you're going to touch on some of the same themes on your claim of instructional error. Why don't we move to that?
Yes, I imagine I will. I can go on to why the prejudice prongs for this and manslaughter are kind of similar, but I guess I will finish up with that this would have mattered. I know Justice Massing mentioned that bed frame was mentioned, but in a case where no one saw what happened and Mr. Correa this was the only piece of evidence that could have been used by someone who perceived the event. And I think that the jury would have found that to be very important in their deliberations, especially where the evidence in this case was pretty thin. So I will move on to the instructional error. I think the key question for the court on the instructional error is whether or not there are reasonable inferences that could make out the several theories of manslaughter that counsel put forth. So I'll focus on that. The first one is that no one saw what happened, the facts. Smith said that she heard something like someone hit their head and then a fall, and then she sees Mr. Correa on the ground. I want to point out in this discussion that Mr. Leveque had a hammer the entire time. If you watch the video as he's coming into the residence at the beginning, as he's leaving the residence kind of throughout this episode, it's around 2 hours, I think, he has a hammer the entire time. So this is not a circumstance where Smith hears, something like someone hit their head and a fall, and she comes around and Mr. Leveque has this hammer for the first time. He's had it the whole time. So he is holding it, and I acknowledge that, but he's had it the whole time. We have a bed frame. If you look at Appendix 40, 42, and I think 106, there are pictures of this bed frame that's propped up by the door, and there's a diagram at the end. It's either 102 or 106. There's a diagram at the end of my appendix that shows the room layout a little bit better, and it also shows where the blood is, where there's a pool of blood where he fell. And I just note that that's very close to this bed frame. And to the extent that we do have evidence that he was mumbling something about a bed frame, the jury certainly could have used that. So we don't see what happened. We have two people who are arguing with each other, have had this kind of long period of arguing about where these drugs are. And I think it's very reasonable to assume that Mr. Leveque could have pushed Mr. Correa, and he's intoxicated, he has injected heroin, he's consumed heroin, we find out later when he gets to the hospital. There's a very good chance that Mr. Leveque could have pushed him and he could have fallen into the bed frame. There's a chance that he could have threatened him and he stumbled into the bed frame, something along those lines. And in that circumstance, we have to look at the light most favorable to the defendant. We have to look at any
my assessment of the evidence actually suggests to me at least that the stronger view of the evidence was that Leveque used the hammer, but in the light most favorable to the defendant. The medical testimony did not rule out a different cause.
It did not. The medical examiner's testimony was that it could have been any blunt object, and that had a lot to do with the fact that the skull was removed at the hospital. There was no indication of the shape of the object. So we have the medical examiner's testimony, and I think with all of that together, there's a reasonable inference in the light most favorable to the defendant that Mr. Correa suffered some sort of fall from a push or a threat or a lunge, something along those lines, went headlong into the bed frame, and we have this injury, and that's much more akin to a one-punch manslaughter case than it is to a murder, than it is to third-pronged malice.
Attorney Jellison, you
Absolutely.
state in your brief correctly that the judge said, "I'm looking at it in the light most favorable to the Commonwealth."
He did.
Do you think that was that if you look in terms of the judge's remarks as a whole? Do you think that that's what he was doing throughout, or do you think he just misspoke?
When I look at the evidence in this case, I feel like he could have only gotten to the conclusion on the manslaughter instruction that he got to by doing that. I think if you look at in the light most favorable to the defendant, you get to the conclusion that you have to give a manslaughter instruction. So I think it did color his task, I'll say, because I believe the evidence gives that. But that wasn't the only theory of manslaughter. Counsel also put forth that Mr. Correa, we don't know what happened to Mr. Correa in the room, but Mr. Levesque leaves him, and there's video of him getting up, going out into the hall, and kind of going behind this door, and we have that doorknob covered in blood, with blood dripping down. So counsel also put forth the theory that it could have been manslaughter by omission, where he leaves someone who's gravely injured to go ahead and harm himself more. And then just at its base, between third-pronged malice and manslaughter is just incredibly close. So you have this kind of drunken argument, and there's no evidence that Mr. Levesque intentionally hit Mr. Correa with a hammer if he did at all. With all of that, I think you have to give a manslaughter instruction. And the cases say, Horn, Martinez, both say that where a manslaughter instruction is warranted, if it's not given, that it's reversible error. So, are there any further questions on the manslaughter piece?
Is it automatically reversible error, or?
Those two cases, it's interesting. I'll read the quote. If any reasonable view permitted the jury to find wanton and reckless versus third-pronged malice, I put in, if so, the failure to instruct the jury on involuntary manslaughter entitles the defendant to a new trial. So those cases do seem clear that, where the jury could find this. And I think the jury could have found this. Where the jury could find this, it's reversible error. So moving on, I have little time, but I will hit the chalk issue very quickly. So the touchstone of chalks is that they have to be accurate and fair. And I guess I would just encourage, I was listening to the chalk yesterday, and I covered up the captions, and I know what it says, and I couldn't hear it. But when I put the captions back on, I sure could. Mm-hmm. So we're talking about something.
The prosecutor in closing have argued that their interpretation of what the sound depicted.
I've thought about this question.
And well, I'm sure you did, because it's the obvious one, right?
Absolutely.
The caption is really nothing more than putting in print the same content that the prosecutor is free to argue.
Yeah. So I think the prosecutor probably could have argued some of it. I think it would have been inappropriate where any of the audio was unintelligible. I think that is going beyond the evidence. I think where something is unintelligible, and to me, some of it is unintelligible, I think that would be going beyond the evidence. I think the prosecutor could have argued things that arguably could be one thing or the other. I think that's proper, but I think the captions
could avail themselves of the enhanced audio for that purpose.
Say that again, I'm sorry.
Could avail themselves of the enhanced audio for that purpose.
Right, so the enhanced audio is still quite unintelligible.
I understand.
But I think there really is a difference with captions. And, you don't take my word for it. The courts in Florida Supreme Court and several of the federal courts have recognized this problem, that where you're getting this concurrent information. So if the prosecutor had said, I think he said this at different times in the video, the jury says, okay. They go back and listen, but they don't hear it. I think that they could make their own determination. But where you present to them this concurrent information that actually affects the way that they interpret the audio, that's where I think that this chalk becomes unfair, just absolutely unfair, and that's the touchstone.
This chalk was used only as a chalk and was not admitted as an exhibit, right?
That's correct.
And that makes a difference, right?
It certainly makes a difference, but I don't think it makes a difference in this case, because the jury would have, during closing, had this, and at that point, you can't really erase that. It's the toothpaste is out of the tube. You've already had this suggested information, and I think it changes the way that the jury hears it when they review it again. I think it actually changes the way the jury hears it, so that's why I feel like it's unfair.
Okay, I see the red light is flashing. Unless there are further questions from the panel, we'll hear from the Commonwealth.
Congratulations on your retirement.
Thank you.
Good morning, Mr. Chief Justice. May it please the court, Steve Nato on behalf of the Commonwealth. I'll begin where my sister did with the ostensible excited utterance. I know that the defense in its reply brief relies on Tang. There are a lot of principles enunciated in Tang that I do not dispute. Certainly that competency is not an element in the terms of testimonial competency that a judge has to, conduct a hearing on. I agree that it's the circumstances in which the utterance is made that makes it qualify for the exception, not the general testimonial competency of the declarant. But I would also note that Tang makes clear that the judge has broad discretion as to both the foundational requirements of the excited utterance and as to competency issues. I think what we're dealing with here is sort of a different kind of competency rather than just purely being unable to testify. And certainly serious head injuries, you can suffer those and may nonetheless be competent. You may be insane and nonetheless be competent to make an excited utterance, but that does not mean that there's a bright line rule in all cases of a severe head injury, that any utterance you make after that, no matter how altered, no matter how diminished, that qualifies under the exception. And I think the evidence and the circumstances here make clear that the injury that the victim had suffered was so severe as to sort of render his statements unreliable. As descriptions of anything that happened, it was sort of incoherent, non-responsive mumbling. I know there's testimony that he also said backpack in this.
If we agreed with you on that, would we be making new law to say that it met the criteria for an excited utterance, but yet the judge has the authority to keep it out? I
don't think it would be making new law, because I think it falls within the judge's discretion that it did not meet those requirements. And I would refer to Commonwealth versus Santiago, which I think is cited in my brief, which talks about, they describe it as kind of a nexus. It's not a separate requirement in the analysis, but it's sort of with like temporal nexus and subject matter nexus is an element in that second prong.
The difficulty that I'm having is that it depends a little bit on how you view the statement in its context, on whether you think it reveals an understanding or a comprehension or an awareness of the surroundings or not. Because the victim was asked, what happened to you? And the victim said bed frame. And if you adopt the Commonwealth's view that the injuries were inflicted by Mr. Leac with a hammer, that makes no sense. But if you adopt the defense theory that it may alternatively have been an unfortunate impact during a shoving match, that he hit his head on the bed frame, it makes perfect sense.
Well, at first, there's certainly no evidence of a shoving match or a...
Well, I guess it was kept out, right?
Well, as to that statement, if that statement is competent as evidence of a shoving match, perhaps, but if he's falling into a bed frame with the force, the medical examiner testified it would require a substantial amount of force to cause this injury.
All fair game for argument.
Absolutely. But that, of course, presumes that this statement is competent to come in. And there is one point where the judge keeps it out when the officer says, what happened to you? The response at that point presumably would have been bed frame. But he testifies prior to that that in kind of this incoherent mumbling, he says backpack, he says bed frame, and he's not responsive. The paramedics are in agreement that he is completely unresponsive. I think the only thing that he responds to is once they read his tattoos to his name, they're able to get him to confirm his name. But that's it, and then he ceases shortly thereafter. And I don't know if this was testified to, but the prosecutor, in discussing whether the statement would come in, mentioned to the judge that also he was asking for his mother in that interaction. So I think that there's no, that bed frame is about as likely a response as to what happened to your head as backpack or mother. The evidence
maybe,
here.
but that was the first thing that was said. That was the first words that were said after the question was asked, right?
At that point, but there was, again, some testimony, too, that he was just kind of mumbling words, and bed frame, backpack came out then. And it could be that, there's the officer testified when they arrived, the bed frame was in the doorway. He's trying to get out, the bed frame's in his way. It's not just kind of what's in front of him, but under the circumstances, the judge had broad discretion to determine whether this was the product of, an exciting event related to that event, or if this was just a incoherent mumbling as a result of a head injury that had rendered him incompetent.
If we think that it should have been admitted, is our review prejudicial error or beyond reasonable doubt?
If it had been admitted substantively, I do think we'd have a problem, because that would have opened up perhaps an involuntary manslaughter and structure.
I think it connected with that too makes it worse. But just in terms of if we're just on the issue of spontaneous utterance, admitted, not admitted. If we say it was an error to keep it out, is that a harmless beyond reasonable doubt analysis, or is that a prejudicial error analysis?
That would be prejudicial error, as opposed to the extent that it arguably implicates not exactly a third-party defense, but alternative means of.
Maybe a defendant's right to put on a defense. Does it implicate that?
That would implicate a constitutional
right
claim, and thus be harmless and
beyond reasonable doubt.
But as to the
substantive
evidentiary rule, generally that's an abuse of or prejudicial.
Why don't we move on to the instructional
Sure.
question? You just said a moment ago that if this evidence should have come in, that would create an error on the instruction. Why is the same argument not available even in the absence of the defendant's own statement, given the configuration of the room and the many things that we don't know about precisely what happened when the impact occurred?
Well, I would suggest that Judge White hit the nail on the head when he said that any of those alternative explanations required speculation to bridge the gap. If that statement is kept out.
What's the distinction between speculation in these circumstances and drawing inferences from the facts that were in evidence?
Because it ultimately has to insert facts that are not based in evidence, that don't allow a reasonable.
What facts that are not in evidence are beyond the scope of proper inferences? Because what I can imagine, and I think what the defendant is arguing, is that visible in the room was an upended bed frame, metal bed frame, with a protruding leg. The blood from the victim's head and from the injury was on the floor, very close in proximity to that protruding metal frame. No one saw the impact that led to the victim's injuries. However, the defendant was in an agitated state and suspected the victim of stealing his drugs. And so now tell me which elements suggesting the bed frame rather than the hammer as the source of the victim's injuries relies on unfounded speculation as compared to inferences from those. What are the missing facts that are required to support the inference?
Well, given Ms. Smith's description, just any evidence that after the thump, that there had been sort of physical contact preceding the thump, causing him to fall into the bed frame and then the fall. Well,
the fact that the defendant struck him with a hammer requires an inference, doesn't it?
Not that he fell into the. Well, no, I don't. An inference.
No one saw it.
Yes, but I think that's the reasonable inference based on the sound.
Put in the light most favorable to the defendant.
Yes.
The facts in evidence would support another blunt, hard object as the source of the impact that led to the victim's injuries, right? He could have stumbled himself and fallen without a struggle.
But again, there no evidence of that.
I know.
And
no one saw what happened.
Well, understanding that we are looking at this in the light most favorable to the defendant, just as an aside, I do think there is a inference could be drawn that Shannon Smith, in fact, did see what had happened based on certainly the video of her in the immediate aftermath. Saying you killed him in the small quarters of the room.
Credibility. I mean, I put on the table earlier my own view of the evidence that the hammer is a far more, in my view, likely cause of the victim's injuries.
Yes, more likely, but I understand that's not the question.
Jury were given that as a choice. They were not given the other as an alternative. And the defendant now says that was unfair and caused him prejudice in the jury's opportunity to convict on the lesser included.
And so I suppose that the best I could do maybe is by a comparison with what inferences are there regarding the hammer strike and the kind of absence.
You need to exclude. You need to exclude as purely speculative, the inferences necessary to support the alternative theory in order to defend the omission of that charge.
So, again, there's no indication that the bed frame at any point moved, that there was a sound of Shannon Smith was standing right next to it, supposedly, when this happened, for him to fall into the bed frame with sufficient force that went unnoticed by her, but she was able to sort of differentiate the verbal argument, the thump, the sound of the fall.
I don't recall if the evidence tells us how large a man the victim was.
I don't recall that specifically, but I think you can see their relative sizes in the video. And certainly the defendant is tall enough that he'd be able to reach up and whack the guy.
I'm not talking about height. I'm talking about weight and the physical force of a fall or an impact from a loss of balance. Would that possibly, in the minds of a common juror, suggest the possibility of an impact hard enough to cause those injuries?
I think there's simply no evidence.
Well, the medical examiner was unable to,
second impact,
even with their expertise, to offer a view of what the likely cause was, right?
I'm sorry, could you repeat?
The medical examiner, even with their expertise, declined to offer an opinion about what caused the injury.
Sure, and that was under the circumstances where part of the skull had been removed, so he simply could not say. But that does not provide, I think, based on an inference of what happened in the room, that some other object other than the hammer.
No forensic or accident reconstruction or other testimony that said that based on the mass or the weight or the force that the bed frame was not a potential source of the injury.
Again, I think that there's just no evidence from which I think you can infer that he struck the bed frame. I think it comes, again, there's not a ton of facts to work with here, but it does support there's a verbal argument, the sound of a thump, nothing going on with the bed frame, and then a fall.
So the inference certainly is that the thump was the impact on his head.
Yes.
So we know that something came into contact with his head causing the injuries.
Yes.
We don't know what that was. It doesn't have to be the bed frame, it doesn't have to be the hammer, it could be any other hard object in the room, right?
I disagree. I think that would require speculation in a way that concluding that the hammer was the cause of the injury does not, based on the defendant's conduct throughout the hours preceding it, brandishing the hammer, from the immediate threat to Shannon Smith. Once the victim is at his feet, you can get it too.
That's certainly an argument to the jury based on the evidence.
Yes.
Can I ask a slightly different topic? So I made the mistake of looking at the impounded exhibit before lunch one day last week. What is the relevance, the probative value of the autopsy photo of the brain in the head with the skull removed?
Well, that one I'm not sure bore directly on any particular issue in a way that the other one, the pre-autopsy photo and then the brain itself, I think those are relevant. But that one, arguably not, or went too far, but there was no objection to it in any event. So under a substantial risk of miscarriage of justice, that doesn't lie where during the impanelment, jurors were kind of put on notice about this. They were instructed at the time, and given the verdict, indicated they were not overcome by sympathy or emotion from it.
Thanks.
Thank you. Thank you both. The case is submitted. The next case on our list for hearing is case number 2023 P1259, the Commonwealth versus SENGDAO, MOONSAMROUATH. And if I have mispronounced the defendant's name, I apologize.
Good morning, Mr. Chief Justice. Your Honors, may it please the Court, Nathaniel Stetson from Middlesex on behalf of the Commonwealth. This case simply does not feature the kind of hardcore transgression involving bad faith or intentional delay that would necessitate or permit effective dismissal with prejudice under Pimentel, and therefore this Court should reverse the motion judge's decision. To begin with, the record simply does not show any egregious misconduct, not by the prosecutor who was in the courtroom at the time, not by the district attorney's office, not by the police, and we know that the standard...
I'm sure that you saw in the defendant's brief, they did actually a very nice job of inventorying the numerous cases that are consistent with your position, and yet the defendant argues that they illustrate why what we're doing is not enough.
Yes, Your Honor. I did see those cases. They were well organized, and they reinforced the Commonwealth's point that the law is clear that the kinds of transgressions that occurred in this case are significantly less severe than the transgressions that occurred in cases where...
Let's talk a little bit about the bigger picture, which is, even assuming that you're correct that this case can be distinguished, the fact of the matter is that now more time has gone by. The Commonwealth went up to the SJC 3 times in order to finally, before it figured out exactly where it was supposed to be. We can talk later about whether or not that borders on problematic conduct. And now, of course, if we were to agree with you, because the cases say what they say, and it goes back, what have we accomplished?
The correct outcome under the law, Your Honor. The correct outcome given that the Commonwealth engaged in good faith efforts to bring the case to the motion, and the fact that when it failed the correct remedy at that point, given that the judge was well within his discretion to deny the continuance, was dismissal for lack of prosecution without prejudice, at which point the sanction to the Commonwealth takes the form of time under Rule 36. That's the sanction that this Court and the SJC have decided is appropriate when there is a I would call it either an accidental or a negligent or an inadvertent mishap in the courtroom is time, which counts against the Commonwealth. And I think that's well established by the cases. And I think that we do see Rule 36 motions permitted where the Commonwealth has been dilatory, and even where it hasn't engaged in bad faith conduct, that trial clock runs out. If no one's in the wrong, it's still on the Commonwealth to achieve the prosecution in a certain period of time. With regard, and I'm happy to talk about it now, to the Commonwealth's single justice practice, I can tell the Court, the motion judge's ruling was confusing to the Commonwealth. He did not state that the motion to suppress was allowed. His margin endorsement said that the evidence was excluded. The Commonwealth read that as a discovery sanction, which would not be 15A-able, and so proceeded under 211.3. It was also not immediately clear whether the single justice had allowed the motion to, or had upheld the decision on the motion to exclude the evidence, or only the motion
to continue.
Denial of the motion to continue. So we required
the first trip to the single justice appears that was what the focus was, because that was what was addressed in the single justice order, the motion to continue.
And the Commonwealth probably could have been slightly clear about the scope of its request, but was not being dilatory. Again, in the single justice practice, we were confused by the nature of the margin endorsement and the nature of the judge's sanction. And when it became clear that the single justice wanted us for clear reasons to treat this as the allowance of the motion to suppress, we then proceeded under 15A. But the litigation did not stall. The Commonwealth was proceeding with the litigation consistently for the entire period of time.
I know it must be, you know, it's as I've been an ADA in Lawrence District Court, which is comparable to Lowell District Court, and it is frustrating when the officers don't show up and you can't reach them. Might it be helpful if we actually ruled in favor of the defendant to try to get the police officers there on a more timely basis?
No, Your Honor. I agree that it is frustrating, but this is not, of all the cases, this is not the case on which to do that. There's no record of prejudice to the defendant. The defense attorney had already moved for continuance of the motion and it was allowed without objection. There's nothing in the record about prejudice to the defendant, to the defense, to the case, nothing about any consequences to him. And essentially the only thing the defense can point to is inconvenience in having to come back to court again. But we know from Ortiz that where a defendant is not held in custody, that does not constitute the kind of prejudice that merits this draconian sanction. So if the court wishes to pick a case to hold the Commonwealth's feet to the fire, I would submit that this is far from the case that it should choose.
On the other hand, the ADA, even at the second time that appeared before the judge here, it was a different ADA at that time, still did not know why the officer did not show up, and still did not have an answer for the judge then why the officer didn't show up, and I guess fairly valiantly offered to go to the PD. I think it was a woman herself to find out. Seems to me at that point in time, that information could have been obtained.
Perhaps it could have been, Your Honor, and it was not.
So to Justice Massing's point, does there come a time when an appellate court needs to be a little more forceful and say something a little bit more about this so that it doesn't repeat itself?
Well, I think it has, Your Honor. I think if you look at the cases that have been assembled, I think we've seen instances where witnesses have refused to come to court even though they've been in close contact with the prosecution and the court's been able to speak with them. That's led to an evidentiary sanction, essentially. And I think that we've seen cases where prosecutors have essentially talked back to the judge, refused to go forward on counts that they could go forward on, or where there was an opportunity for them to proceed and they essentially refused to do what the judge ordered. But even where a prosecutor was not physically present in the courtroom, that case, if the court recalls, was found not to have merited the dismissal with prejudice. The busyness of these courts, I think, ties into the suitability of Rule 36 as a sanction. Another thing that we don't have in evidence on this case is any indication from the judge, the motion judge, the defense attorney at the time, or defense counsel thus far, as to the proportion of cases that reach this stage. And I think that it would be premature of the court to publish a case, again, to sort of hold the Commonwealth's feet to the fire, where there hasn't been any finding in this case, where there hasn't been any finding at all about the severity of the problem, the magnitude of the problem.
I'm a little confused about the procedural posture in here. What we're deciding is whether or not to allow a motion to suppress hearing to go forward. Right?
Yes, Your Honor. Whether or not to reverse the judge's ruling that the motion to suppress was allowed without any evidentiary hearing.
Okay.
Which this is, again, goes to the confusing nature of it. It bears many of the hallmarks of a discovery sanction, but it's been treated by the single justice as the allowance of a motion to suppress. We're asking the court to overturn the judge's decision, allowing the motion to suppress without an evidentiary hearing, and allow the Commonwealth to hold the motion to suppress, on which I think the facts are quite strong for the Commonwealth.
What happens if the officer doesn't show up the next time?
If the officer doesn't show up the next time, Your Honor, it would depend on the communications that the Commonwealth has with the officer. It would also depend on the communications that the defendant has with the court and any findings that the judge makes at the time. I think what's striking about this case is the complete lack of findings by the judge as to, as to the bigger picture, as well as to the actions of this prosecutor who's in the courtroom or these officers in particular.
Just one more question. Why not? So, I mean, busy district courts happens all the time. Why not call the first witness? And there's a witness there. There was a witness was on his way, or you had 2 of the 3 witnesses there. Why not go forward?
One of the the witness who was still completely incommunicado was the one who had actually recovered the contraband. The ADA in session at least believed that that witness was essential and necessary to the motion. I do think that going forward on the motion and requesting a suspension of the evidence would have been another appropriate action, but it was not. It may not have occurred to that person, and given the busyness, the press of business, I think they may have been making their best efforts to obtain the witnesses. I would just like to quote very briefly from Clegg, which points out that in these busy cases, it can be frustrating when witnesses don't appear, when things don't go as planned, but the unexpected can and often does happen. The need to move the business expeditiously in busy trial courts must not lead to such draconian sanctions as occurred here. That's from Clegg at 202. And with that, if there are no further questions, I would rest on my brief. Thank you.
Thank you. For the defendant?
Good morning. Alexandra Deal for the defendant. I'd like
Thank
to...
you, by the way. I meant what I said to the Commonwealth's counsel earlier. The chart that you put in your brief I found very helpful, but it erects a very tall barrier for the argument that you're trying to make to us.
It does indeed, Your Honor, and I appreciate that. But I think this is an instance in which, Justice Vuono, you asked, what have we accomplished? And my brother said the correct outcome under the law. I think this is an excellent opportunity for this court to change the law, because I think that chart, while it is in some ways not helpful to my position, also demonstrates why it is so important to change how things have been going in this Commonwealth for the last 30-some years, perhaps more. It really is a case about...
Well, what I hear from you is the suggestion that if we decide this case consistently with the law, that you'll craft a rather impassioned petition for further appellate review and maybe take that up with our friends downstairs.
I think that's a reasonable assumption, Your Honor, because I would actually disagree that this is not the case in which you could make this decision, because I also disagree that this was a case of inadvertence or accident. This was a case where the hearing had been on for months. The prosecutor well knew that she needed 3 witnesses at that hearing. It sounds as if she summons the witnesses, and 2 of them just didn't show up.
Well,
and
to be fair, when you say it sounds, can we agree that the representation was made, that the 3 witnesses had been summoned?
Yes, Your Honor.
All right. One was there. One was on the way from a crime scene. And the 3rd one was, I think we can basically say, sort of MIA. Nobody heard from the 3rd one. Is that right?
That's right,
Okay.
yes.
All right. And the Commonwealth had not asked for a continuance yet, right? I mean, you're absolutely correct. The case had been on for quite a while. But this was the first time that the Commonwealth needed a continuance. The reason why I ask these questions is because when we talk about, is this the right case, with all due respect, if we talk about maybe we need to do something about what's going on, I want to be sure that this wasn't really just sort of a run-of-the-mill first time around, and maybe it's not the best case to be discussing this.
And I think that's a fair question, and you're right, but I think there are a couple of things to keep in mind. The first is that the case got a second call. So if the witness was on his way, he certainly hadn't shown up by the time the case had the second call. And then there's the question of the 3rd witness. Right. And I think that's really the crux here, because we operate in a system where if the defendant doesn't show up, a bench warrant is issued. The defendant has to be where the defendant has to be. It should be the same for the Commonwealth. It should be the same for the Commonwealth's witnesses. I'm not suggesting the police ought to be thrown in jail if they don't show up, but what I am suggesting is that there has to be a system for accountability, and that's what's lacking here. And that is exactly what the judge said. He said, If I dismiss this case without prejudice, why would I do that? That's a non-sanction. It's just an invitation for the Commonwealth to circumvent my order and to rebring the case. That's exactly what I don't want to have happen here, because the sanction has to mean something. And
Except that you would have already had your trial by now. You would have already had your motion heard, and you'd have already had your trial, and your client would not still be waiting had things been done slightly differently, if the judge had ruled without prejudice.
in all likelihood, that's true.
And of course, the other issues that would have been in place to protect your client, like Rule 36, et cetera, would have still been in play.
That's true, and it's hard to say how it would have played out had it not gone this way. I do also think that procedurally, the Commonwealth, I do think it was clear that the motion to suppress was granted. The court said, a motion to suppress is a request to exclude evidence. The court said, I'm excluding the evidence, and the clerk read into the record the motion to suppress was granted.
Yeah.
At that point, the Commonwealth had Rule 15 at its disposal. Mm-hmm. It didn't take advantage of that, and not only that, it waited almost half a year.
Well, but that is something that at this point is beyond our authority to deal with. The SJC has authorized the Rule 15 appeal to proceed, and here we are.
That's true. I think it was more to the point that we were discussing earlier, just about the general delay in these cases. And this was not a case in which the Commonwealth was rushing to get things done. And so I really do. I want to emphasize that I think this case is about the big picture, just as you said.
What about a different sanction? Hypothetically, where the judge said, well, $50 an hour until I hear from this witness, or something like that, to really, when we're talking about trying to hold the Commonwealth, the feet to the fire, or take care of the system, what do you think about something like that?
I can't think in this case, or really in any other case, about what a sanction like that might accomplish. I don't even know if that sanction is available. But, if it were...
Often for discovery violations, a monetary sanction is imposed, even in a criminal case. Okay. Court's time, effort, et cetera. So we don't have to quite answer that, but assuming that it is feasible.
If that were feasible, Your Honor, I don't see a reason why that would necessarily have been inappropriate here. I think the real question is, it would not have been appropriate, I believe, for the judge to dismiss the case without prejudice for exactly the reasons the judge said. And I do want to touch a little bit also on the prejudice to the defendant, because we've been talking about, whether there was a showing of prejudice. I think I have two answers to that. The first is that when Justice Graziano got this case on the 211-3 petition, he found that the judge hadn't abused his discretion in allowing the continuance. So in finding that, he necessarily found that the judge made the appropriate balancing calculus, and part of that balancing calculus is whether the defendant is prejudiced. And I think it was in Commonwealth versus Graham where the court said, you're really looking at two sides of the same coin here. So if there's reason for one, then there's likely not reason for the other. So in this case, if there's reason for the continuance, then there is prejudice to the defendant. And while it's true there's not a robust record on the question of prejudice, I hope that it's appropriate to recognize that every day that a criminal charge is pending against a defendant, there is prejudice. It is not just a criminal conviction that causes a defendant prejudice. It is when the charges are pending, a defendant may lose his or her job, a defendant may lose housing, a defendant may lose custody of a child.
As Justice Vuono alluded to earlier, there is an entirely separate independent regime to regulate that, right? The right to a speedy trial, and we have a whole set of rules. This took place well within that rubric. And I understand that every day is prejudice, but the mechanism, this was the first continuance the Commonwealth sought.
That's true, but again, I would point you to the chart that's either helpful or unhelpful, depending on how you look at it.
It's very helpful.
Thank you. There are cases where it has been 2 times, it has been 3 times. The prosecutor has just not bothered to show up, and still the court says, well, dismissal with prejudice is too draconian a sanction. And I think what those
What
cases...
we have is this case, and we have those cases. And so you're quite right. We would need to abrogate a number of prior authorities in order to reach the result you're asking.
I'm not sure you would need to abdicate them so much as you might need to be somewhat more specific about what amounts to the kind of conduct on the part of the Commonwealth.
A more
that would necessitate-
severe conduct, more intentional, deliberate, obstreperous, or negligent conduct was not enough to warrant the draconian sanction in those cases. So we would need to, in effect, I said abrogate, but we would need to overrule those prior cases in order to reach this result.
Or perhaps redefine what it means for conduct to be egregious, because I think while the conduct in this case wasn't bad faith conduct, it wasn't good faith conduct either. It was an unprepared prosecutor, it was an absent police witness, and it was a situation...
Let's remember there were 3 witnesses, and when we talk about bad faith, one was present, one was on the way.
That's right.
Right?
But for the third, the one who was MIA, there was absolutely no explanation where that person was.
Sort of goes with the territory of someone who's MIA.
Yeah.
Well, sure, it does. But I think that's important, and the reason that's important is because had the Commonwealth made the effort to contact each witness prior to the hearing, and this goes, again, to it is a busy
It always
court
looks,
system.
when we encounter a mistake or a challenge, the corrective preventive measures always are so clearly defined in retrospect, aren't they?
They are, but I think that's why the cases that have come before this are so instructive.
Well, but I
because
think
this continues to
encountering this
happen.
kind of a disruption, this kind of a disappointment in being able to move the case forward stands as a fairly strong incentive to the prosecutor to do a better job the next time. I doubt that this prosecutor will make that same mistake again.
That may or may not be true, but prosecutors as a whole continue to make this same mistake over and over again, and I think that's what those cases show us.
I understand the theory. I have, at various times, had conversations with attorneys for the Commonwealth in these hearings, asking if they ever have a discussion with their colleagues when they get back to the office about what we care about up here.
Well, if there are no further questions,
Seeing none,
Thank you.
the case is submitted. That brings us to the third of the criminal matters on our list for hearing, and we will be taking a brief recess after this next case before we resume the session with the civil part. But the next case on our hearing list is case number 2023 P265, the Commonwealth versus Julio C. JOAQUIN. And again, I apologize for any mispronunciation.
Good morning, Mr. Chief Justice, Justice Vuono, Justice Massing, and may it please the Court, Attorney Juan Rivera for Julio JOAQUIN. Today we are bringing before you this case about Mr. JOAQUIN, who was convicted of violating a restraining order. And we have several arguments with respect to the vacating of the judgment that we're asking for. The defendant was deprived of his right to present a defense with proof of prior convictions of the individual who we are calling Jane Doe, who applied for the restraining order. The defendant was also deprived of his right to confrontation of the police officer who served the restraining order. And that is significant because under Chapter 209A, Section 7, we argue that the police officers who serve these orders have an enhanced duty to fully inform the person served. It's written right there in the statute. Our third argument is...
Did I miss something, or did you raise that confrontation claim for the first time in your reply brief?
I don't think that the confrontation issue was specifically addressed in the opening brief.
Not. So well, let's not spend a lot of time on that one.
Okay. The trial judge, his denial of Mr. Joaquin's attorney's request to allow Mr. Joaquin to have the conviction of Ms. Doe was prejudicial error, Your Honor. This is borne out.
Let's start with how was it prejudicial? You know, the inability to confront a witness who admitted that she called the defendant, that she texted that she was drunk, that she was way drunk, that she texted the defendant 50 times to come over. What aspect of her testimony did you want to impeach?
I think that the trial attorney wanted to undermine her testimony, her intention in doing what you stated with regard to inviting him over. There could have been additional strategy with respect to her reasoning, her...
Doesn't matter though, does it matter? If she had it, I wanted him to violate the restraining order. It doesn't matter, does it?
Well, it also goes, I think, to whether or not he actually knew about the restraining order, whether he was fully informed, whether he could have...
Well, she couldn't have testified about that.
She testified that he didn't know that English was not his first language.
So, I mean, but that's helpful to you.
What is it about her testimony that you were trying to discredit? And that the inability to discredit resulted in prejudice for you?
Well, it would have to do with what is generally put forth when it pertains to impeaching a witness, which is the veracity of the individual.
I understand,
and
but
specifically,
I want to understand what portion of her testimony challenging the veracity would have been important or valuable to the defense.
it could have been any testimony having to do with his knowledge of an existing restraining order.
But she did not testify about his knowledge. She testified about her actions in inviting him over, her state of mind, her intoxicated condition. The testimony that talked about his having been served with the restraining order came in from other sources. So what of her testimony would benefit the defense by discreditation, by impeachment?
I think it would have been regarding his understanding, her perception of his understanding of whether or not a restraining order existed, Your Honor. The other evidence that came in was from a police officer who arrested.
That evidence generally is under our cases thought to be sufficient to establish or charge at least the defendant with knowledge of the restraining order and its requirements.
Which is?
The testimony of the officer, the fact that he was served with the restraining order and the restraining order itself.
Except that the officer did not, in effect, give the restraining order. The testimony that the officer who was present at the trial offered was that he determined there was a restraining order after the fact. I don't think that they got into whether or not.
Well, the return of service, typically under Shangquan, satisfies that the element of establishing that he was served.
Shangquan is an issue in this case, Your Honor, because the defendant was given a piece of paper, but as I mentioned in the actual statute, there's an affirmative responsibility for the person serving that paper to do more than that. And so, since that wasn't followed here, the defendant was deprived, again, of his right to confront that individual. And also, the language barriers that the defendant had in this case, which was apparent from his use of an interpreter, also was not allowed to be challenged because of the lack of an officer testifying. The language in the return of service was also pointed out by the judge to be ambiguous when he was instructing the jury. He said, before he instructed the jury at sidebar, he indicated that there was nothing seeming about the invitation here. And he himself, the judge, was confused, the trial judge, about whether or not confused, but he was indecisive about which instruction to give. And I think that is something worth considering here with respect to the prejudice that Mr. JOAQUIN endured in this case. Your Honor, the other issue that we have in this case is with respect to the trial judge putting a juror on the panel, the jury panel, with whom he was familiar.
How does the relationship between the judge and a juror matter?
It goes straight to the heart of having an impartial.
Juror has to be impartial as to the parties, the witnesses. The judge has no role other than presiding over the trial.
It also has to do with the appearance of impropriety.
Can you point us to any case in which the familiarity between a judge and a juror was called into question?
I could not find one, Your Honor.
Not surprised. I said I'm not surprised that you couldn't find one.
Right.
Because it's not a thing.
Well, when you have a juror that you're familiar with and then you appoint them as the jury foreman 10 minutes before lunch, with a trial court officer asking, what are we going to do about lunch? And then the judge, presumably in front of everyone, says they're going to deliberate and give no instructions with respect to lunch. I think that's a signal there. It's not the strongest point in the arguments that we're making, Your Honor, but I think accumulated with the others, it's worth considering in this case. I think if you were to ask any layperson about the dynamic of that, they would be surprised that this would be allowed, that a judge would know somebody and do everything I just described and allow there to be a verdict. And in fact, there was a verdict, maybe 20 minutes into the lunch hour. And so there isn't case law on this, Your Honor. That's why we have these courts to determine whether or not that would be proper or not. I would suggest that the stronger arguments have to do with respect to the lack of allowing a criminal record to come in, that the judge cited Saunders, that he cited the wrong Saunders case, there's two of them, and that he did that thinking that he was exercising his discretion.
Well, actually, I mean, Saunders, the issue in Saunders is whether there has to be proof that the defendant was represented by counsel, right? And that's what the SJ, and the judge initially seized on that, but by the end of the discussion of it, the issue was whether there was a certified copy, and that part of Saunders has not been overruled or changed. There has to be a certified copy of the record, right?
No, they're just not. The Saunders, my reading is that after the decision on that case, it would be presumed that the certification.
It is presumed that counsel was there, hasn't it? But you still need what you offered, or what trial counsel offered, was at RA 23. Is that right? Record Appendix 23.
Mm-hmm.
It says Commonwealth versus Jane Doe.
Yep.
So this is the record that you'd like the jury to consider.
Yeah, it didn't say Jane Doe. This is the redacted copy.
Okay, that's helpful.
Yes, everything that's Jane Doe in the record appendix is all redacted.
Okay.
The originals were submitted, but as you can see in the record appendix, there's more than one document. There are various documents, and this is similar to the other cases where they would submit blue.
Are there other documents having to do with her criminal record?
Correct.
Where? I don't see that.
In other cases, I was referring to Commonwealth versus Puleo.
Okay, right.
Where they allowed other documents to come in. The certification is to certify whether or not there's been counsel. That's why in the cases that were cited, they're all out-of-state cases. And because we, as a sovereign...
Certification is a certification of the record. There may have been an element of that record that also went to the question of counsel, which was at issue in those other cases. But the certification of the conviction itself goes to authenticity, or the foundation for admission of the record. I have some recollection that is a required element in the statute authorizing the admission of the record. But
yeah, the statute itself doesn't say anything about certification. 231, section 233, section 21, there's no mention of certification. I would argue that the certification is to certify that there was that there was actual counsel. That's why in the case, it indicates that after a certain date, it's no longer required. And so, in this case, the trial counsel's ability to do so was not allowed, and that resulted in a case which we're asking you to vacate the conviction.
Okay.
all right, thank you.
Thank you.
From the Commonwealth.
Good morning. May it please the court. My name is Emily Walsh. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. The trial judge properly denied the defendant's request to impeach the victim, where the attorney did not have a certified copy of the conviction. The case law, the most recent of which is Walters, makes clear that a certified copy of a conviction is required for impeachment.
Can I ask about Walters? It says a court record or a certified copy. So what is a court record?
That is a very good question. I am not clear on what they mean. I assumed, in thinking it through, that perhaps it was within the same courthouse bringing up a court record rather than making a copy of it. So in Pulea, they had a court record, essentially, which was a blue sheet from probation. And the defendant got more than he was entitled to in that case, but the judge opted to hold a voir dire with the witness and then the witness admitted to certain violations on this blue sheet, which is arguably a court record, and the judge allowed impeachment on what the witness admitted to. However, the judge did not allow what was reflected on the blue sheet court record but not admitted to. So I think that case, a close examination shows that not just any record qualifies as a court record within that definition. And then in Walters, there's not a lot of discussion about what it was, but what the evidence was, but it does say no error in declining to allow the defendant to, quote, impeach the credibility of one of the Commonwealth's witness with evidence of her criminal conviction, but without a certified copy, and it's not clear what that evidence is. But the cases repeatedly say that a certified copy is, it would be nice to have more clarity on what that means, but since Pelea does analyze what a court record, a blue sheet from probation, and makes clear that that's not enough standing alone. But in any event,
it's, as you say, an actual record that belongs to the court or a certified copy, right?
Right. And as Your Honor asked my brother about, the victim's testimony was largely favorable to the defendant. So even if there were any error with the certified conviction, which there was not, the factual basis of the complaint, the fact of the defendant coming to the victim's home, was really undisputed. The defense was that the defendant didn't understand the requirements, and the victim offered no testimony on that. So any impeachment value was really minimal to none.
The judge gave an instruction on accident because I think there's nothing closer in the model instruction. So it's really if the plaintiff gets a restraining order and then they contact the defendant in the restraining order and ask them to come over, and the defendant comes over, that's illegal.
That's correct. That's correct. That's on the face of the restraining order, even if the plaintiff seems or allows contact. In the brief, it does say the trial judge indicated he would instruct the jurors on the effect of the invitation, but ultimately did not. The record, the transcript on those pages, the judge says, well, maybe I should give something about that. What are you looking for? And the defense attorney said, I just want the model instruction. So there was nothing requested that wasn't given. There was nothing promised that wasn't given. It was part of a discussion. The defense attorney asked for the model instruction, and that's what he was given. And the RO went to the jury, and the prosecutor did call attention to the part of the RO that says contact is prohibited, even if the plaintiff allows or seems to allow contact. Moving to the sufficiency arguments, the first argument that the victim invited the defendant does not make the evidence insufficient. The Commonwealth is not required to prove that the defendant actually intended to violate the order, only to prove the act that constituted the violation was voluntary, in this case, that act being the defendant going to the victim's house. The second, there was sufficient evidence to establish the defendant knew the terms of the order. He was served in hand. As to the language issue, there was ample evidence that the defendant understood English. The texts that he received from the victim were in English. He answered booking questions in English. He did not request an interpreter at booking, and at trial, although he did have an interpreter, his attorney stated, quote, just for the record, he speaks pretty good English, but we have an interpreter here because of legal jargon and that type of thing.
Are the texts in the record? Are the texts in the record?
The texts are not in the record. The victim was asked what language she was. No, I'm sorry. The officer, I believe, was asked. There was testimony describing the language of the text. The texts themselves were not in evidence. And finally, even if the defendant did not understand the order, where in-hand service is sufficient to put the defendant on notice that further inquiry is required, he did not. But again, there was ample evidence that he did understand the order, and the order was not ambiguous. The defendant argues that the exception to pick up his personal belongings in the company of the police at a time agreed to by the plaintiff, that this, quote, could have been happening in this case. That was not the defense raised at trial. There was no ambiguity in the order, and the trial judge properly acted within his discretion in seating juror number 10.
I just have a question that's a little bit outside of this case specifically.
Sure.
And that's the following, if you can answer it. So on a superficial level, I'll say superficial because more on an objective level, there's a restraining order. The person who is against whom the restraining order is issued is invited to come over by the victim. The case law says that is not, and that's not an affirmative defense.
Correct.
We follow the case law, right? But there's got to be the only, I'm just curious as to whether or not, because these cases are always very complicated, how much prosecutorial discretion is normally applied in a case like this to determine whether or not it's the kind of case to bring forward? Is there a flat rule, every single violation of 209A comes, we prosecute, period, or is there more of a nuanced approach?
I can't really comment on this specific case. I would note here, I understand what Your Honor is saying, that the nature of the violation, returning keys at the victim's request, is not really...
And to be clear, I was asking a little bit outside, of a bigger picture, if you can give us some information.
I would like to think there's always some discretion, but I don't know. And we don't know, I know you're not asking within the record, but we don't always know the history of the parties or what was in the affidavit 5 days before the violation occurred, what had been happening that led to the issuance of the violation. You know, I understand Your Honor's question. I don't have a great answer for you, but in the context of this case, there are a lot of facts we don't know. And
This is one of those occasions where, when you get back to the office, maybe you can have a conversation with your colleagues.
I trust that it was brought for good reason. I don't know broadly exactly how much consideration goes into.
Well, you answered my question. Some discretion is involved with the case. So that gets me where close to what I was thinking about. Thank you.
Are there any further questions from the panel?
Seeing none, that concludes the argument in this case. It is submitted. We will take a 15-minute recess and resume hearing the first of our 3 civil cases at 11:20.
Thank you.
The next case on our hearing list is case number 2023 P852, Tyler K. Larson versus Amy Larson. This case, just as a reminder, is partially impounded. I'll just remind counsel to refrain from reference to any of the impounded material.
May it please the court, Jamie Moritz James for Amy Larson, the appellant. The appellant contends the lower court decision to bar the removal of the children to Alabama with mother constitutes an abuse of discretion, as the judge made clear errors of judgment in her findings. The court denied the mother's request for removal despite finding that the relocation was a real advantage to her and that the children would benefit by economic and psychological benefits to the mother, including a lower cost of living in close proximity to her family and friends. The judge failed to assess the impact on the custodial parent and did not give appropriate consideration to the benefit of the move of the children. Balancing the real advantage with the child's best interest, the judge found that the move was not in the children's best interest, not because of the inability to provide a suitable working alternative parenting time, which is a factor, but rather an incorrect factor, the effect of curtailment of the child's association with the non-custodial parent, herein the father. The disruption in visitation cannot be controlling, or no removal would ever be approved by this court. It allowed and it outweighed the mother's real advantage to moving to Alabama. The mother argues the judge gave undue, in effect, dispositive weight in the disruption of father and the parental visitation with the parental grandparents over her advantage, her sincere advantage.
What is our standard of review?
The standard review here, Your Honor, is the Giannis matter. And in doing that...
Well, no, I understand what the factors are, but we are reviewing for abuse of discretion, correct?
Yes, Your Honor.
Okay. And these cases are notoriously challenging.
Understood, Your Honor.
Each one requires a highly nuanced, factually intensive review of a myriad of individual circumstances.
Yes, Your Honor.
So when we're trying to evaluate the best interests of the child, the judge needs to take into account both the role of the custodial and the non-custodial parent in the child's life, right?
Well, first, Your Honor, the judge needs to see if the custodial parent has a sincere reasoning for the move.
We're past real advantage on this. The judge acknowledged that this move would result in real advantage to the custodial parent.
Yes, Your Honor.
And the judge appropriately, I think, reviewed those circumstances and reached that conclusion and started with that baseline, in fact. But then the next step is real advantage standing alone doesn't carry the day. It's a question of what would be in the child's best interest. And in evaluating that, the judge needs to incorporate consideration of the effect not on the parent but on the child of the relationship with both the custodial and the non-custodial parent. Is that correct?
Yes, Your Honor, but the non-custodial's relationship with the child cannot be outweighed by the other factors of the real advantage to the mother. In this particular case here, Your Honor, the judge erred by not considering the effect of the mother's unhappiness should she be forced to stay in Massachusetts, and how her happiness, if she was allowed to move to Alabama, could affect the children. She also used the incorrect standard in evaluating the effect on father's relationship. It's clear father has a relationship with the children, but that should not be the sole and prominent factor here. It should be determined whether or not there has been proposed a parenting plan that is a fair parenting plan that would allow father to see the children. In this particular case, Your Honor, is stated in the findings that mother gave more time to the father if she was allowed to move than if she was forced to stay here. In doing so...
Where is it? I was looking for that in the findings, and I couldn't find that. Where in the findings is that, if you would, or if you can give me a paragraph number?
I don't have the paragraph number. It is in my brief, Your Honor.
Actually, there's no citation in your brief to it either. There's no record citation to that.
I believe...
You argue that it hardly affects. But
The judge did state in the brief that mother had offered significant more time to the father. She specifically states summer vacations, and in that being, she was willing to give him 6 weeks. She was willing to give him spring vacation, and that is noted in the brief. So the mother was willing to give him substantial amount of times, Your Honor. Basically, what the judge did was she made a determination that the father's parenting time, along with his parents, superseded the mother's advantage. Now, more importantly here, the court finds that the children's lives are enriched by each parent's participation in the upbringing. These findings would not support a decision in denying removal. There are no findings and there's no evidence suggesting that the children would not continue to do well emotionally, physically, developmentally, if removal were allowed. Now, in regards to Justice Green's question to me in regards to the best interest, the mother in this particular case not only gave the father significant amount of time for him to be with the children, she also was willing to take less child support, share cars with him, have him stay at a carriage house should she be allowed to move. In regards to this particular matter, which is very fact-driven in regards to each case being different, mother, who has always worked for Raytheon since she graduated from college, she's had one job, she has been the primary breadwinner for this family. Father, on the other hand, during the course of the short-term marriage, roughly, had made significantly less money than mother, and during the marriage, he had been laid off for 8 months. Mother's job is very important to her. During the course of the case at hand, mother had accepted a job in Alabama working for Raytheon. Specifically here, Your Honors, the court did not value the fact that mother had been the chief breadwinner in the family, that her means to support the children were invaluable. In addition to that, Your Honor, there is no case law that says that the parental grandparents should supersede the custodial parent's time. The appellant is the custodial parent. The appellant had started this matter when her children were 9 months and 2.5 years old. Specifically, at the time...
One of the challenges I'm having in hearing the way that you are presenting, and I don't mean this to sound as harsh as the introduction would imply, but everything that you are saying views this question through the lens of the two parents. And of course, our charge and the charge of the trial judge is to evaluate the best interests of the child from whatever perspective that may originate. The flaw, it seems to me, in some respects, is a flaw in our entire system because the children are not present. We have a guardian ad litem who conducted a report, and I understand the guardian ad litem included their recommendation to allow removal. But the paramount concern here is the best interests of the child, and if the children have relationships with schoolmates, with teachers, with parental grandparents, with whomever else that would be disrupted in a manner that the judge considers to be adverse to their best interests, that is in fact something that we need to take into account, that the judge must take into account.
Yes, Judge. Specifically, again, not to reiterate to your honors, but this case started when the children were 9 months and 2.5 years. At the time of the hearing, the children were 4 and 6. The children were in daycare. What relationships, what extracurricular activities would those children not have been able to make had they gone to Alabama? They were very young children. Had my client lost her position in Alabama and not had a job, what would have the difference been had she had left Middleton, Massachusetts, where the children were in daycare, and moved to a different city in Massachusetts? Those children would have still had to make the same new relationships that they would have had to make with their change in Alabama. Your honors, you cannot look at the fact of what was the relationship and have with the father and the grandparents and have that outweigh all the other factors that are listed in the second prong. There was no expert that testified that these children would not be able to have an upbringing, a good life, or that there would be any impairment on them in Alabama. More importantly, I would state here, Your Honor, that the court erred by using the incorrect standard in evaluating the effect on father's relationship, as I said. She put undue weight on the children's relationship with the parental grandparents. Again, there's no case law. And considered the relationship that a 4- and 6-year-old had made in being in daycare.
I wonder if you can help me understand what seems to be something of an inconsistency in what the judge described about the mother's employment situation.
Yes, Your Honor.
At one point in the judge's findings, she said that Raytheon said that they can't guarantee her a job if her removal petition is denied. But it also says that she has opportunities to advance her career in Massachusetts.
Your Honor, there was no evidence that talked about her being able to advance her credibility in Massachusetts.
Her career.
Her career, yes. I would state to you that the judge also failed to consider FaceTime or the alternative means of communication. The fact that mother was giving father 6 uninterrupted weeks in the summer, clearly there's an opportunity for the children to spend time with their grandparents and the father. She was looking to take less child support so that the father could be able to afford to stay there. Now, most importantly, father moved out of Massachusetts. As soon as he filed for divorce, he moved out of Massachusetts and moved in with his parents in New Hampshire. Father could have chosen to stay closer to the mother in Massachusetts. The court also goes on to state that mother should be able to call upon her in-laws to help take care of the children. You will see throughout the judge's findings that the court talks about the abuse that mother sustained. Mother was not going to call father, who basically would yell at her and scream at her and then rely upon his parents to help take care of the children. Mother has 0 relatives in Massachusetts, 0. She is the primary custodial parent. The judge has findings that specifically state that if mother was to move to Alabama, she would be near her sister. Her parents had gotten a rental home. They were going to watch the children for her while she worked. She has no one. And the court, in the lower court states, mother should be able to contact her employer's child care provider to take care of the children. Your Honors, the appellant is under almost a jail sentence staying here in Massachusetts. She has limited friends. She goes on specifically to state the judge has no idea. The one thing that the appellant does is she goes to some game on Wednesday, like a guessing type of a game.
Trivia night.
Trivia night, yes, thank you, Your Honor. And the judge isn't even sure who she goes with. She went 5 times when she was married with a husband. Living here as the custodial parent, the judge did not fairly weigh the advantages and the happiness of the mother against the parental visitation of the father. And there is not enough of documentation in her findings specifically to say that the court specifically erred that it was in the father's interest, quote, in her findings, it says, it is in the father's interest for the children to remain in Massachusetts. What about it being in the best interest of these children? Furthermore, the court goes on to state, in parentheses, Your Honors, the court goes on to state that the judge speculates as it not being in the children's best interest. And again, I would state that that was in quotes. The court found that residing near a mother's family would positively affect mother's happiness, which in turn would positively affect the children. Yet the court, Your Honors, failed to put weight on how this overall would impact the quality of the children's lives. There was no amount of weight placed on that. And I would ask, Your Honors, that in looking at this, the court said, without any findings to support it.
You've reached the end of your time. We have that in the court's findings. Thank you.
Thank you, Your Honor.
We'll hear from counsel for the father.
Good morning, Your Honors. May it please the court. Samantha Surratt for the appellee, the father in this matter. There is one phrase you're going to be sick and tired of me saying, and that's best interest of the children. Case law is incredibly clear with removal. Just because there's real advantage does not mean it's in the best interest of the children for removal. As we've already stated, the best interest of the children is the touchstone inquiry. It's the paramount consideration. Mother today is seeking that the court place more focus on her hardships and her interests, and less on that, less of the children. That's a very dangerous precedent we could be setting here today, Your Honor.
The reason Giannis placed real advantage at the start of the inquiry is because the benefit to the custodial parent can have an enormous impact on the best interests of the child and their sense of security and well-being.
Of course, Your Honor, and the court acknowledged that. The trial court did acknowledge that. Mother found that the real advantage is exclusively mother residing closer to her family. That's it. The court found that mother did not have an economic advantage by moving to Alabama. The court found that mother could afford her lifestyle and save at the same time here. She purchased a single-family home in Middleton, Massachusetts on a single income prior to her marriage, and that she could not advance, the court found that she failed to provide, that she could not advance her career in Massachusetts. Remember, she's been employed by the same employer, Raytheon, an incredibly reputable employer, since 2007. So the only advantage...
Did she not also find that there was more expansive job opportunities in Alabama?
That was unclear because mother took a job. I noted it in my brief.
That is a finding, is not, that the judge made?
Correct. However, mother voluntarily quit her current job prior to the start of trial to take one in Alabama. As noted in the record, mother did it on a leap of faith that the court would move her to Alabama. So she voluntarily put her job at risk for a trial strategy is what we believe actually happened. She's been, during this, from 2007, she's been with the same employer gainfully the entire time.
She is still going to be employed by the same employers.
Correct. Different facility. And it is noted in the record, we did go to trial in October, Your Honor, and then she said on the record she had 3 months to be in Alabama or else she didn't know if she would have a position. The judgment came out in March, so more than 3 months. The record is absent of any indication she lost her job, her income, anything like that. So that move assumably did not obtain.
We don't know.
Correct.
So you're really speculating right now. We have no idea what's happening currently.
The record doesn't indicate that because it came out in March. There was no filing afterwards that she lost that income.
Well, but just to go back to my question earlier, the judge's findings on the mother's employment do strike me as being somewhat inconsistent or at least unexplained, to the extent that the judge finds that the mother could not be assured of a position with Raytheon were she to stay in Massachusetts, but then goes on to say that she would have opportunities to advance her career in Massachusetts without saying what those were. Do you have any insight? What was the evidence that would have supported the latter finding?
I believe it was just that mother's been employed since 2007 with the same employer. Throughout the time, she was taken on different roles.
With Raytheon, which is a highly specialized company, right? They're a defense contractor, and the facility down in Huntsville is If she's not able to work for Raytheon in Massachusetts, what was the opportunity to advance her career?
Your Honor, she is an engineer and she has extensive experience. So honestly, we don't know it is lacking in
What was
the
the evidence of the mother's, I mean, I understand quite often when we deal with typically more in support orders, with a spouse who's underemployed, we look at their prospects for employment. Was there evidence about prospects for alternative employment outside of Raytheon in Massachusetts?
There was not. She never looked. She moved from Alabama.
I'm not asking what the mother did or didn't do. Again, I'm concerned with the best interests of the child, not with the culpability or responsibility of the parents in terms of meeting some requirement. I just want to know what the evidence was that supported the judge's statement that the mother had the opportunities to advance her career in Massachusetts.
That I don't believe is in the record. I don't believe mother testified to that.
So if it's not in the record, there's no support, and the finding is clearly erroneous.
I believe it's noting, the judge noted that mother moved here in 2007 to get a career here in engineering. When she graduated from college, she voluntarily moved on her own here to start her career here. So I believe that's what the court relied on for this.
I want to ask a couple of follow-ups on Attorney James's argument. The first one is, I was going to ask, the judge found that the father moved to Kingston, New Hampshire, and that his parent, and he's from there. Did he in fact move back with his parents? Is that what the evidence is?
Correct. So I do want to clarify, my sister did state he moved there not at the start of the divorce. What the beginning of this proceeding was is that father was served with a restraining order, essentially had to vacate out of the marital home within minutes. So he moved to his parents because he had nowhere else to go. He couldn't secure housing. So it wasn't when he filed for divorce. It was when he was served with a restraining order because he had nowhere else to go.
Okay. And I mean, Attorney James does have a point that in every single one of these cases, it's going to be a detriment to the relation with the parent who remains if the child is taken away. So what is it in this case that makes that detriment more, worse for the children than in your average case?
It's the consistency and frequency father has his parenting time, especially we're talking about very young children. So father right now is granted 5 overnights and a 1 dinner visit on a 14-day period. So he sees the children very frequent. He has his Wednesday overnights for a midweek visit to check in how their week going. He has a Monday dinner after mother's weekend to hear how their weekend's going. There's no way that type of relationship can be secured from 1,000 miles away. There was no reasonable alternative.
Or would there ever be in the case of a custodial parent moving to California?
I'm sorry, I couldn't.
Nor would there ever be where the custodial parent moves to California.
Exactly. So this case.
So is our case law that despite a very significant real advantage, that there is a geographic limit on how far the removal can extend?
Yes, however, all the other elements towards the children's best interests were not here. The only element going towards the children's best interest for their move was that the flow that could happen from mother. Their quality of life would not be increased other than the increase in mother's happiness. There'd be adverse effects.
Well, isn't that significant?
There is, of course, but then we have to look at everything else. The judge noted we're uprooting these children from their father, their routine, their daycare, now their school.
As Mother's Counsel observed, these are rather young children. Children are resilient. If they were in their sophomore and junior years of high school, it would be a different story, right?
It may, Your Honor. And case law has noted that stability is an enormous benefit to these young children, especially while they're young, transitioning to school, transitioning out of daycare, dealing with a two-household family. We're dealing with a very large transition for 2 young children to handle. So moving them to Alabama is a great upset to the status quo. And case law is already.
Children are familiar with it, with Alabama. Haven't they gone there a couple times a year, every year? Don't they go to Alabama and spend the holidays there, et cetera?
They do spend about 1 or 2 weeks in the summer and 1 or 2 weeks or about 1 week in Christmas, but it's not extensive time. As the record noted, the children don't have a meaningful relationship with mother's extended family. And I want to make sure it's not.
Excuse me, that was a finding by the judge?
That children have a greater relationship with father's extended family than mother's, because father's extended family always.
I thought I heard you say that there was a finding that there was no meaningful relationship with the mother's family. Is that correct?
I apologize, I don't believe those in there.
All right.
And it should be known, it's not mother's extended family versus father's extended family, but the reality of the situation is father's family has always resided local to this family during the marriage and during the separation. They heavily relied on father's family for babysitting frequently during the marriage. So if the removal would be allowed, we'd be upsetting the children's relationship with father's extended family, whereas mother's family lives in Alabama. The status quo, or Alabama and Mississippi, the status quo would remain the same for them. They would visit and see the children the exact same amount of time. So we have the ability to keep the consistency for these children, both parents present, and the status quo for their extended family. So that's why we're seeking that the judgment be affirmed, to keep the consistency and the stability for these children that is in their best interests. And I want to be very clear, my sisters state that this is a jail sentence for mother. This is not a jail sentence for mother. Mother moved here on her own, away from her family in 2007. Mother only resided in Alabama when she was going to college. This isn't a case where mother's seeking to go home. She was raised in Mississippi, not Alabama. She's been here since 2007. She purchased her single-family home that she continues to reside in today with the children in 2011 on her single income. This is not a jail sentence. She got married in 2013, and the parties began raising their family here. This is not a jail sentence that she's stuck in. It's saying that she can stay and provide stability for the children. And Your Honor, as I noted, ultimately, we're just keeping consistency and stability for these children. We have the ability to keep these children safe, safeguard their relationship with both their parents. Both their parents were found to be loving and participating. Father was found to be an active and hands-on caregiver. As case laws noted, with Justice Green's point to California, this case is extremely similar to Murray v. Soper and Dickinson v. Cogswell. In both those cases, father had consistent and frequent parenting time with the children, and the court found that that could not happen being a flight away.
In Dickinson, if I recall correctly, actually I think I was even on that panel, the plan involved a rather young child flying unaccompanied across the country on a red-eye with some regularity, and that struck us as not making a lot of sense. Each case turns on its own facts.
Correct. And here, mother's proposed parenting schedule allowed for father or the children to fly. So on one stance, we'd either need the young children again to fly from Alabama to Massachusetts.
Plan here is for the father to visit the children in Alabama, right?
Mother's proposed judgment had either the children travel here or father travel there.
But not on a regular overnight flight.
Not on a regular overnight flight. However, the visits were Friday to Sunday or Friday to Monday, depending if it was a long weekend. So we're requiring frequent flights. It's not it's not across the country, but it's still a frequent flight for these young children to take. And also needs to be noted, if the children are traveling up here every other weekend, that greatly impacts the extracurricular activities or the lives they can put in Alabama because they couldn't participate in the soccer games or the practices that occur on the weekends. We're taking the children away every other weekend, or father has to fly down there and take off Monday and Fridays from a full-time job that doesn't allow to go remote, but also provide suitable housing, provide meals without access to a kitchen, and give them activities, because 2 young children in a hotel room will likely get a little stir crazy. So the flights in this is going to be extremely stressful because there's quick turnarounds. Mother's proposed judgment relies greatly on that there's readily available flights, that they're reasonably priced, they're never canceled or delayed, and that the children can do these flights by themselves. There's a lot of assumptions to mother's proposed parenting schedule relying on this quick turnaround that's not reasonable. And it's honestly not realistic for 2 young children to maintain their relationship with their father, who they have frequent and consistent parenting time with. So, Your Honors, as I stated at the beginning, we're looking at the best interests of the children. We acknowledge mother has a real advantage. But again, that is exclusively her being closer to her family. That is it. There's no other real advantage to mother. Everything else goes towards the children and their best interests. We are seeking to have the children remain where they are. There's no need to uproot these children from their friends, their family, their daycare, now their school, their active, hands-on caregiving father. Their one home they know. That's what we're seeking before you. The court weighed all of the factors with appropriate, weighed all the factors with appropriate weight. There's no workable schedule that can have father to continuous, frequent, consistent parenting time with. I want to make one thing clear. My sister noted in her memo that mother's proposed schedules altered his parenting time by 3 to 5 days per year. I ran the numbers and I ran the calculations. That is very different from what I'm getting. When I looked at what father's parenting schedule is, which they've been doing since September 2019, he has 173 to 175 parenting days. The varying is based on how the holidays fall, odd or even. Under mother's proposed parenting schedule, it's 129 to 130 parenting days. This is 45 days less with your children a year, each and every year for young children. That is a drastic difference for these two young children that we have a long time to go. And also it needs to be noted that children seeing their father twice a week for dinner visits, check-in, going to see soccer games is extremely different than father seeing the children once a month, regardless on the length of time. So we are before you seeking that the best interests of the children remain the paramount consideration and that you affirm the judgment of the court. Thank you, Your Honor.
Thank you. Thank you both. The case is submitted. The next case on our list is a case involving termination of parental rights. It's case number 2023-P-1013. The case is impounded, and I'll remind counsel not to refer to the parties by name, mother, father, child, etc. We did not hear from the counsel for the parents as to how they would be dividing their time. We have assumed for preliminary planning purposes that you'll be dividing your time equally. If that's not the case, let us know. And then lastly, after the conclusion of the argument in this case, we are expecting some visitors who are going to be sitting in and watching argument in the last case, and so we will take just a pause. We will remain on the bench, but allow those visitors to come in and take their seats before we start argument in the last case. I don't think they're here already. I think that it's a larger group. Yeah, no, they're not. Yeah. All right, and with that, we will hear argument from the two parents. I gather beginning with counsel for the mother.
Good morning, Your Honors. Tamika O'Brien on behalf of Mother. Your Honors, the evidence as developed in this record does not support termination of mother's parental rights to her children. Your Honors, in this case, DCF did not present evidence of mother's current unfitness. Lots was said about her substance use or history and her mental health, domestic violence, and housing situation, but rarely was this evidence current. And when it wasn't, there was not a nexus established.
The judge found, I thought, that the mother remained substance dependent and remained mentally ill. And also remained without stable housing. Right?
I'd like to tackle housing first. I was reviewing the record this morning, and there was evidence in the trial record, or the trial transcript, that she had received a letter of eviction. And then there was other evidence that she was still living in Granbury, Connecticut. I didn't see any evidence that she was not housed. DCF did not present any evidence that she was not housed. In the 18 months before trial, she was housed. As far as her substance use is concerned, Your Honors, Father testified, or he had called DCF and told them that he believed mother had relapsed based on his observation of seeing her close her eyes for about a minute while watching TV. Not to mention the fact that, as we know from Commonwealth versus Eldridge, the SJC recognizes that relapses are part of recovery. Again, DCF doesn't show any evidence here that mother's substance misuse, if she indeed still had a substance issue, had any nexus on her ability to parent these children. If you look at the visits, not just the visits, in this case, mother was maintaining 2 jobs, had maintained housing, had visited consistently and appropriately with father, None of the visits had ever been terminated because of mother's behaviors. She never appeared not to be sober. The trial judge herself said in the introduction of her findings, mother appeared sober. There's no indication here that mother's substance use or mental health issues impacted her ability to meet the basic needs of these children. If you look,
Can we go backwards a little bit?
Sure.
Was there a finding that the parents actually moved to Connecticut sort of to get out from under DCF? You don't have to answer that. But so if the parents moved to Connecticut, doesn't that sort of hamper DCF in being able to show current evidence and they also resisted an interstate home study too, right?
I'm not sure that they resisted the home study. Was their decision to move to Connecticut probably the wisest choice? Maybe not, but there were other factors to be considered. Father wanted to get mother away from the triggers that she had in Massachusetts. She continued to receive her methadone treatment, which is very important in recovery. She, again, maintained 2 jobs. How many of our cases here do you see where a parent is maintaining 2 jobs and housing and visiting, even from afar, in COVID times?
I think you mentioned also something about, what was the evidence about visitation with these 2 children?
The evidence, the visitation, initially a visitation was 1 hour weekly. Then it went to virtual when the pandemic happened. The DCF had contracted with an agency to supervise the visits. The social worker, and I believe it was worker Williams, testified that she would kind of jump on the visits, maybe the last few minutes of the visits. So the visits, the records of the visits and how the visits went came from another agency, which were emailed to the DCF social worker. So that was the indication that they had. And everyone in this case testified that the visits went generally well. And that's very important because in care and protection of Whalen, the court stated that the nexus between the mother's mental health and her fitness as a parent was evident in Whalen's reactions to his visits with mother. In this case, even though the older child, he had ADHD and he had an IEP, and there were some behaviors that happened at school, no one ever mentioned that these behaviors happened with mother in her visits, with father. This family visit went as well as it could go during these times, especially trying to engage 2 small children on a computer screen. Later on, I think it was June of 2021, father requested in-person visits. And again, there's no indication that anyone, there were no observable behaviors that supported reducing or terminating visits. I think that the issue here is that there was a lot that had happened in mother's life. I think she was a consumer child with DCF. She obviously had issues with other children in the past, but these children she had remained connected to, so much so that the trial judge, despite her reservations with this mother as a parent, had given her 3 post-termination and post-adoption visits a year. That is really telling about this particular case. And DCF did not present evidence of the nexus there, and that's the most important thing. Yes, she had substance issues, and yes, she had mental health issues that she acknowledged was going to be a struggle for her whole life, and she had worked hard. But the nexus, like, you can't just say, and the case law supports, you can't just say she has these issues and not detail how it relates to her ability to care for these children and her parenting capacities. And Your Honor, my time is running out, so I'd like to close with the fact that, again, this parent was not perfect, but I think that the nexus in DCF's proof here, it was so weak that any rational overseer could not conclude that this mother was currently unfit, and therefore we ask for this panel to reverse and remand.
One quick question before you sit down. You do not press the argument that the department failed to make reasonable efforts. Is that because this actually fits into one of the exceptions where they're not required to make reasonable efforts?
Well,
they both argue that in their briefs.
if you have a moment. I think that, and I don't want to go over too far, I would like to address that because, yes,
Well,
I think...
if you press the argument, we have that in your brief.
Okay. I will rest on that then. Chief Justice, enjoy your retirement. Justice Messing, thank you. Justice Vuono.
For the father.
May it please the Court. I'm Attorney William Como. I represent the appellant father. I would just like to clarify my sister's statement that the mother has a history of substance use disorder, but there's no record evidence that mother's use of substances continued after November of 2020. She was sober when this trial started at 7 months, and when the trial ended for approximately a year.
Well, the judge disbelieved that, though, right?
The judge disbelieved the mother's statement to that effect, but that in and of itself doesn't establish the fact that she, in fact, was abusing substances. There was no evidence in this record to suggest otherwise.
She had a history throughout the prior proceedings of denying use and then having that denial be demonstrably incredible.
That's correct. But in this situation, again, there's no demonstration that it was incorrect.
She didn't provide clean screens.
No.
That would have been an opportunity.
I apologize, Judge. I believe she did do screens through her methadone treatment agency. She didn't provide the screens to the court. That's correct.
Your time is limited, and you're here to talk about the father. Let's move on.
Thank you. I've laid out all of my argument in my brief. I just want to, I guess, focus on a few things. And the first thing would be the court's conclusion that there was domestic violence in this relationship. The first thing I'd ask the court to look at is the fact that the judge referenced the action plans 3 times, 3 different action plans in her findings. And in each of those action plans, the task of domestic violence services was never included in the action plan by the department. So it raises the question, well, the judge didn't find that the department didn't make reasonable efforts by failing to provide domestic violence services in the action plan. And in fact, the judge found that the department did make reasonable efforts by the tasks included in the action plan. So if domestic violence was in fact a live issue in this case, then the judge made an erroneous finding that the department made reasonable efforts when it didn't include domestic violence in its action plan. In fact, there was no history.
Okay, so where the parents had prior children removed, was the government required to make reasonable efforts?
The department's always required to make reasonable efforts.
No, there's actually several exceptions to when they're not required, isn't there, under the statute?
Under the statute, there are 4 exceptions, and none of those apply in this case.
When their rights have been removed with it.
I'm sorry, Judge.
Isn't one of the exceptions when their rights have been terminated with respect to with siblings?
That was not a finding by this court. Well, I apologize. Certainly, it was a finding that the rights had been terminated as to other siblings. But no, I don't believe that that's the exception for a requirement not to make reasonable efforts, unless the department had, and I apologize, not anything that I briefed, and this is just from memory.
Sorry. Okay. Let's go back to the father.
No, but I believe the department has to make a request of the court not to make reasonable efforts during the pendency of this case if there's a prior hearing in which the parental rights had been terminated, and that wasn't done here. Everybody understood the department had an obligation in this case to make reasonable efforts, otherwise they would not have provided services at all, or recommend services in any event. So, Your Honors, concerning the domestic violence, again, there is no indication in this record that there was domestic violence between these parents. The judge, in fact, said there's no physical violence and concluded that there was basically emotional abuse. But the judge never defined what she meant by emotional abuse. It basically said that because of this emotional abuse, I find that there is domestic violence.
There were quite a number of calls to the police, right?
Yes. Yes, father...
And the mother's explanation and the father's explanation, again, strained credibility.
In what way, Your Honor? I apologize for asking. I'm not understanding your question.
Shouting in the background. Mother said that the call was made inadvertently. When there was evidence of breakage in the home, and said no, there wasn't any kind of an argument or a fight.
No, right. And a lot of this stuff occurred quite a while back. And the mother clearly has mental health issues. She made a lot of statements that were not accurate here. But to say that she was intentionally doing this in order to administer abuse upon the father, I think there has to be some sort of intentionality on her part. And I would argue to the court that it's more of a...
To have an adverse effect on the children.
I'm sorry, Judge, with the air conditioning, I'm having a hard time.
I said not for it to have an adverse effect on the children.
No, true. But I guess my point is not that this, I disagree that it was abuse. I disagree that it was intentional. That it happened, that the mother would do these things, yes. But father made it very clear throughout his testimony that when mother was having a mental health crisis, when he suspected that mother was using substances, he would separate from her, or he would ask her to leave, or he would leave. When he suspected that mother was using substances, he did not enable her to use substances. He left. He left her when she was at the shelter in, I believe it was Springfield. He got back with her when he believed that she was sober, and he did that over quite a long time. He was devoted to his wife. This is not an enabling situation. This is a man who is trying to maintain a relationship with his children and comply with his vows that he made to this woman when he married her. But he never placed the children's safety at risk when he maintained that relationship. And that's the thing that the judge does not appreciate in her findings. Jumping to conclusions that father had done what was an enabler, where there's really no evidence that he did enable anybody. He maintained the safety of, his safety and the safety of the children. I see my time is already up, so unless the court has any further questions, I will rest on my brief.
Thank you, and thank you for the arguments in your brief as well.
Thank you.
Good morning, Your Honors. May it please the Court. Lauren Yankowski on behalf of the Department of Children and Families. The trial court carefully considered the evidence in this case of mother's ongoing issues with her mental health and substance abuse, both parents' housing instability, both parents' unstable and chaotic relationship, and their failure to maintain engagement with DCF and benefit from their services, and reasonably concluded by clear and convincing evidence that both parents lacked parental fitness. This was the correct decision. This is a case where both children were born with special needs due to being born substance exposed, and the court found that they had a significant need for stability in addressing these issues. The court also found that the parents were not able to meet this need. Child 1 was born with ADHD and also struggled significantly in school. He struggled with focusing and staying in his seat. He expressed frustration quickly, prone to temper tantrums, required many breaks, was on an IEP for social emotional support, and had 2 types of therapy, both inpatient, in the home, and outpatient. Child 2 was also born substance exposed. She had specific early intervention needs which required at least 1 hour per day of exercise. She needed occupational, physical, and speech therapy. Over the course of the care and protection proceedings in this case, Mother never contacted Child 2's early intervention worker. And although the department provided both parents with their children's doctor's contact information, they only availed themselves of that information 2 or 3 times over the 5 years of this case. The court found that neither parent is prepared to effectuate this level of stable care needed for these children. That is the key theme of this case, stability. Parents...
The older child previously had been committed to the permanent custody of the department
Yes.
under a care and protection proceeding. What changed, warranting the termination rather than just permanent custody?
What changed? It was more like what didn't change, Your Honor. The parents were not making any significant strides, and so the department determined that it would be in the best interest of Child 1 to be able to be adopted by his loving pre-adoptive home. So parents are not able to provide the stability these children need due to mother's untreated mental health issues and substance abuse issues, both parents' housing instability, and the parents' unstable and chaotic relationship.
Could you address both the housing and the current evidence of substance dependency?
Yes. So I'll start with the housing. Throughout the pendency of the care and protection proceedings, both parents were in and out of shelters, mother was in and out of rehab, both parents were living in their car. At the time of the first day of trial, they had month-to-month housing, but...
they had what?
Month-to-month
Okay,
housing.
month-to-month. Okay. That was the apartment in Granby.
Connecticut, yes. Yeah. But the parents were already struggling with their landlord. Mother called the police on the landlord or the landlord's family 7 times, and the landlord had served them with a notice to quit. And between the first day of trial and the last day of trial, there is evidence in the record that they did lose this housing. The trial court found a direct link between the parents' housing instability and mother's personality that led to having conflicts with roommates and landlords. For example, mother got into a physical fight with another roommate over food stealing, and there was another incident where father had called the police on mother. So already at the time of trial, it was clear that the housing was not stable, and it turned out not to be. Now, as for mother's sobriety after November 2020, mother's argument is that there's no evidence in the record to say otherwise, so that the trial court was required to believe her testimony that she had been sober. This is both factually and legally incorrect. First, November 2020 was the month I moved to Connecticut. Mother stopped communicating with her DCF worker in December of 2020. She refused to interact with her after that point. So to the extent there's a dearth of evidence in the record from that time period, it's due to mother's own actions. Now let's talk about the evidence that is in the record. Mother had no relapse prevention services in place other than methadone and about monthly urine screenings. She was not attending a rehab program. She was not attending a group like Narcotics Anonymous. She was not attending individual therapy. Father reported in the past that mother kept urine in the freezer to fool drug screenings. And during this time period, mother visited her family unsupervised when both her mother and stepfather had substance abuse issues, and the court found that mother and her mother would share drugs. Father himself reported that she relapsed a week before trial. Although he recanted this at trial, the court was entitled to not credit his testimony or credit mother's testimony that she had essentially quit cold turkey and that for the first time in 20 years it had worked. But more than that, even if mother had been sober between November 2020 and the time of trial in July 2021, the court would still be justified in considering her 2 decades of substance abuse as a factor toward her unfitness. The case on this point is adoption of Elena, 446 Mass 24. In Elena, the court upheld the trial court's decision to terminate parental rights, even though the parent had periods of sobriety, because of a pattern of relapse. And as a reminder, mother substance abuse was just one of many issues in this case that interacted together. Mother's substance abuse, mental health issues, and their housing instability and the chaotic and unstable relationship contributed to an unstable environment for the children, where it would not be in the best interest of the children to live. So I'll briefly address mother and father's unstable relationship because it came up as my colleagues were discussing. Throughout 2011 through 2021, mother filed for 7 abuse prevention orders against father. Father filed for 1 abuse prevention order against mother and also filed for divorce 3 times, including once a week before trial. But at trial, he told the court that he intended to co-parent with mother. After trial, father remained living with mother and decided not to pursue the divorce. This on its own is an unstable and chaotic relationship where it would not be in the best interests of the children. Finally, I'll briefly address mother's mental health issues, unless there are any questions. The court found that mother had been diagnosed with bipolar and depression, and she appeared to suffer from hallucinations. She also suffered from suicidal ideation. There's an incident in 2020 where she ran out of the emergency department into moving traffic, and when she was brought back into the hospital, she banged her head against the wall until she had to be restrained. At the time of trial, she was not in any services to address this. She was not attending individual therapy or doing any of her action plan tasks, apart from taking methadone.
Can you address the reasonable efforts issue?
Yes.
Was the department required to make reasonable efforts or not?
My answer to that is no, Your Honor. Well, first of all, the department asserts that it did make reasonable efforts and that mother just failed to avail herself of them. But furthermore, adoption of UDE holds that a determination by the court that reasonable efforts were not made shall not preclude the court from
It's a
making...
different question. Your
Yes.
first answer was that the department was not required to make reasonable efforts, and I'm curious why.
I'll retract that, Your Honor. I'm not actually sure.
Idea.
But in any event, the department did make reasonable efforts here. The mother did not avail herself of any of those efforts and refused to engage with her action worker after December of 2020. So my time is up, so I'll conclude that the trial court's decision was supported by clear and convincing evidence and should be affirmed. Thank you.
Thank you. We'll hear from counsel for the children.
Good afternoon, judges, counsel. Rebecca Hain for the children. Neither of my clients ever lived with the mother or the father. Both of my clients were removed after being born as substance-exposed newborns. They had to remain at the hospital for withdrawal, and then they never lived with their parents. The older child had lived in his current foster home for 4 years at the time of the termination trial, and the younger child had only lived in her foster home. That was the only home that she knew. The children request that the court affirm the decision of the trial court.
Just to be clear, they're different homes, right?
They're different homes. They are different homes. But the judge ordered sibling visitation in her findings, and so that they will continue to see each other. I also want to argue about the reasonable efforts. It is my understanding that DCF doesn't have to make reasonable efforts according to the statute if the rights were involuntarily terminated two siblings of the children, which occurred in this case. So I don't think DCF had to make reasonable efforts. However, I do think DCF did make reasonable efforts in this case. The social worker was working with the parents, attempted to meet with them once a month, created new action plans every 6 months. On the action plans, there were services that were suggested to help the parents make changes so that they could be fit. There were referrals in the action plans for these services. The DCF was willing to make referrals for the parents, but the parents, in order to get a referral from DCF, the parents would have to sign a release, and the parents refused to sign any releases. Mother refused to even meet with DCF. So DCF tried to make reasonable efforts, even though I don't think that they were obligated to in this case. I think that the record is clear in this case that the parents had a long history of substance abuse, a long history of inconsistent mental health treatment, a long history of unstable housing, and a long history of an up and down relationship. And that was the history, and that continued from 2010 when the parents first became involved with DCF, when they had their first child together, through the end of this termination trial in 2022. So I think that the parents' arguments are just their disagreement with the trial court's decisions about the weight of the evidence and the credibility of the witnesses. And I think that the trial court is in the position to judge those things, and she did not make any clear errors, so I think that her decision should stand. I was going to talk a little bit about the children's significant needs. I think clearly in the record there's discussion about the older child who was of school age having issues with ADHD and having to have an IEP. And in the action plans that DCF made for the parents, they had information about the collaterals that the older child was involved with, but neither parent availed themselves of that information to find out about what was going on with their child and what his special needs were. As far as the younger child, she had early intervention, and the adoption worker said that the family that she was with worked with her an hour and a half a day on exercises. In the action plans that DCF produced for the parents, they had the early intervention workers' information. Father testified that he spoke to her 1 or 2 times. He didn't talk about any exercises that he learned from her. He didn't talk about exercises that he did with his child during visits. Mother never even spoke to the early intervention worker. I also think that there's clearly, the evidence is clear that the parents did not follow their action plans at all. Father testified that he met with the social worker, but he refused to sign any action plans, and mother never even met with the social worker, and neither parent signed any releases. So I request that this court affirm the decision of the trial court and find the parents are unfit, terminate the parents' rights, and allow the children to be adopted by their current foster placements. Thank you.
Thank you. Thank you all. Represented on all sides. That brings us to the 6th and final case on our hearing list today, case number 2023 P805, Robert James O'Brien and others versus KIRK Russell and others. And I see that our visitors have joined us already, so we will not wait before proceeding with the hearing in this case.
Sorry.
Thank you. Good morning, Your Honors. My name is Gregory Hession. May it please the Court, I represent Robert James O'Brien. He is the plaintiff in the underlying Superior Court case here, which resulted in a jury verdict in his favor that was overturned by a judgment not on the verdict motion from the defendants. one-paragraph version of the facts. Mr. O'Brien was the live-in partner of a woman who had a child, and Robert O'Brien being a very common name in the Commonwealth, the Department of Children and Families did a background search on him, and importantly to know, they did not use his Social Security number and some other identifying information. So therefore, they confused him with another Robert O'Brien who had a somewhat dangerous history. The Department of Children and Families sent out a social worker.
And the jury, by the way, found that that was not the negligence.
Pardon?
Right? The jury found that was not, there was no liability for that mistake, right? The jury found that was no liability on that mistake of initially mistaking the O'Briens.
Right. The initial, well, I think in the end, yes, and I'll explain, I guess, but the real issue is they sent a social worker out immediately that evening and said, you have to leave now. And the threat was, and this is particularly important under the Mass Torts Claims Act, because they said, if you do not leave, we are going to do a legal consult and consider taking the child of the partner.
Right,
And
but we have the special verdict slip, so we've gone through all of that, and
Right.
it's as Justice Masson is pointing out, the actual initially asking your client to leave, the jury found that DCF was not negligent with respect to that. But later on, by not determining his identity, that was the issue, correct?
well, yes,
The delay,
yes. It went on for 4 months, and only after we filed the Superior Court complaint did they, well, actually, and request an injunction. Even the filing of the complaint did not produce any action. Almost immediately before the time an injunction was about to be heard, to have him asked to be returned to his home.
Well, the jury also found some contributory negligence based on the lack of cooperation that your client had in providing the additional information that the department requested in order to help reconcile the disparity. But nonetheless, in the jury's view, the department could and should have done more to and been more energetic. In trying to resolve the question. That's neither here nor there, because none of that forms the basis for the judge's ruling on the JOV, right?
Correct.
We're dealing with qualified immunity, the economic loss doctrine.
Yes.
And
those are the two issues.
And the
I
absence
think,
of physical manifestations consistent with the emotional distress.
Yes.
Because the emotional distress claims were not covered by the economic loss doctrine.
That is correct, and I think it's consistent with the facts, and one has to admit honestly that he did not produce evidence of physical injury or loss to his property in
or
the
damage.
tort sense.
Right.
Yes.
So you want to take that one first, or do you want to talk about the qualified immunity for the social workers first?
I'd like to talk about the qualified immunity, if I might. Now, this is a situation where, and I'm sure the court has dealt with many of these situations, there is a very extensive framework in the Commonwealth for the reporting and investigation of child abuse claims under our Chapter 119, Section 51A and 51B. If the reporter, and oftentimes it's a mandated reporter, believes that a child is being abused or at risk of abuse, they must make such a report to the Department of Children and Families, and the Department of Children and Families under Section 51B must do an investigation. This was not done. They used rather an artifice that they call safety planning, which appears in no policy, no regulation, no law, or anywhere in any of their literature, and this was admitted by even the area director in testimony in the trial. Now, rather than use the appropriate method that's been prescribed for the social workers to investigate a claim like this, they jumped the gun and did it in an instant determination without the proper investigation that Mr. O'Brien posed a risk to the child. That was and frankly, I believe perhaps because of inadequate training, they probably appeared to not have been even aware of the constitutional rights that Mr. O'Brien had as an individual who resided in the Commonwealth to be safe in his person and property. So
this wasn't his property. He was a guest, right?
Well, he wasn't really. He'd been living there for quite a while.
He wasn't on the lease. He was a guest.
There was, well, I think that there was because the jury found that that these people were liable, I believe it's implicit that they believed that he was a tenant. And if he was a tenant rather than a guest, then he had tenant rights that could not be abrogated by
Is their belief the determining factor here, or is his legal status required to be determined by some other means?
I think it had to be determined by the jury, or they would not have gotten to a verdict that presupposed that he was a tenant and was improperly removed from his home. Because if he wasn't one, then he wasn't improperly removed from his home.
Well, maybe that's why the judge allowed the JNOV. I mean, we're sort of chasing our tail here.
Well, but she didn't really...
If he was a tenant, what was the evidence to support his status as a tenant? He wasn't on the lease, right?
He was not on a lease, and
he was the live-in boyfriend of the woman who was on the lease.
Right, he was the live-in boyfriend in the home, and long time had been there, and helped around the home, and was as much a resident of that home as the owner was of the home. In fact,
a resident, but again, I'm a little rusty on some of the nuances of landlord-tenant law. I'm just not sure that a long-term live-in boyfriend automatically qualifies as a tenant without more.
Well, I understand.
In order to just to be clear, in order to get where you're trying to go, at least on the property interest, you need to establish that he had a legally enforceable entitlement to reside there.
Yes.
If his girlfriend asked him to leave.
His girlfriend did not ask him to leave.
If his girlfriend asked him to leave, would she need to bring some sort of action to terminate his tenancy?
I believe so.
On what basis?
The fact that he was a tenant, and any tenant would have had to follow the summary process.
We're chasing our tail again. I guess I need to know more about why he was a tenant.
Well, he was a tenant by invitation, that they lived in this home together. In fact, she reposed so much trust in him.
Do you have a case that says that someone who is invited to reside in a home for some period of time becomes a tenant by virtue of that invitation?
I don't think that
sounds like a license to me.
Well, it was not just a occasional visitor or a temporary visitor. He was a permanent fixture in that home, so much so that she had established him as the trustee of the trust that owned the home. So that's how much confidence she had reposed in his permanency, let's say, involving being part of that home. I don't have the evidence of a lease and these other things, but we do have.
But the legal status of a property interest is foundational, and I'm just, yes. I guess, a little.
But I think there was enough
that you don't have a clearer path for me to direct me to the property interest that you're relying on.
Well, I think that though we did not have a lease, we have a number of other indicia that showed that he was not just a visitor in the side room or a temporary person, but a person who was part of it.
Let's assume he had a legally enforceable property interest in that place. As you know, qualified immunity attaches except where there's a clearly established violation, right? That the abrogation of his right by the actions of the governmental actor violates something. So what is the clearly established rule that these social workers violated in directing him to leave?
Under Chapter 119, Section 51B, where they had the obligation to do an actual investigation before depriving him of his home. And that.
But I thought you said that this safety planning was something that was, if not a policy, was commonly practiced by the department in a variety of different settings.
It was done sometimes, but I believe it well.
Were there previous instances where that practice had been called out as unlawful?
I don't believe so, because I've never seen this ever done this way. In fact, every case cited by the
There was no evidence of that, right? To get more specific, there was no evidence presented at trial that this particular method of safety planning was somehow illegal.
Was somehow
wrong.
what?
Unlawful in some way.
Well, I think it was because every case cited by the defendants in their brief involved a 51B investigation where the challenge was not this one, but a completely different one. It was to the discretion of DCF having made the wrong decision against that particular parent to then have them be removed or have the children
I understand that, but I guess the concern I have is that the informal nature and prior history of safety planning as a mechanism, whether it is unlawful or not, is an interesting question. But it had not been clearly established by any prior adjudication, correct?
Correct. But that's really the whole point, is it hadn't been established as an appropriate means to use as a substitute for
But therefore,
51B.
the fact that it was, that the social workers were not violating a clearly established rule because it had not been clearly established that this was improper. In fact, it still hasn't been established that it is improper or unlawful.
Well, I think they were violating the clearly established rule by not using the 51B mandate, and it's not optional, it's a mandate, that they must go through a very prescribed set of steps to make an investigation before they make a determination about whether there is abuse or neglect.
I guess I'm not so clear on that, because while it may not be the method that is prescribed by the statute, one can see some value in the overall relationship between the department and a home that they are charged with reviewing in making less process-involved engagements and decisions on a cooperative basis directed toward the safety of the children. Maybe that argument doesn't win the day. Maybe, in fact, you're correct that the only available mechanism for the department to follow is the mechanism that is directed by the statute, and that it's unlawful for them to have informal conversations saying, hey, I think this would be a good idea for the interests of the child, and if you don't agree with us, then we'll ramp up the process. Maybe that's not okay, but no case has said that, and the rule against it, therefore, is not clearly established, is it?
Well, I think it's perfectly okay for them to say to a family, look, we have a problem here, would you voluntarily do this? But this was accompanied by threats, intimidation, and coercion. That's different. And to say, would you please do this until we can straighten this away, that would be one thing. In fact, they had told him, and the evidence was that they told him, well, we'll probably be back, you'll take care of this, and we'll be conversing shortly, and hopefully this will be worked out. They never did. So
You're quickly reaching the end of your time, and I'm sorry because I've consumed a lot of it.
It's okay.
But we haven't talked at all yet about economic loss or
the economic loss rule, and that certainly involves the Torts Claims Act, and the argument that they've raised is an important one, and Mr. O'Brien did not testify as to damage to property. I think that the issue is really going to come down to this. Should the government apply this basically almost only used as a commercial standard type of economic loss rule to a case? The government can do unique damage. The government can do things that a private individual cannot do. And very frequently, the types of damage that it does are very different than the kind of say, in a commercial
Just to refocus, because I know your time is up. This was addressed at trial, correct? And this was, your opposing counsel here argues that this issue is waived on your behalf about objecting to the application of the economic loss doctrine. What do you say about that? In other words, it was discussed at trial, the jury instructions were discussed at trial, the closing arguments were based on this. What is your response to that?
Well, I tried to comply by having as much evidence as Mr. O'Brien could reasonably put into the record about the damages that he did suffer. And he testified about those damages, and they were not property damages, realistically.
Well, as you put it, there was sort of loss of property. He had to spend money to stay someplace else, et cetera.
Exactly. There was a great deal of loss that he had, and as well as emotional loss. I mean, he was away for 4 months. Had to live in a
Well, I guess since your time is up, I didn't see a reply brief filed here unless I somehow I missed it. No. What do you say about the fact that that issue is waived, that applicability of the economic loss doctrine?
I couldn't quite hear the question.
What do you say about the fact that they argue it's waived, that you've waived that issue? What is your response to that?
The weight of the issue?
Waived. I'm sorry, waived. Waived the.
Oh, waived, yes.
Your argument.
They did say it was waived. No, we argued about it a great deal. It was imposed.
Okay, so you
upon
object
me.
to that, just to be sure.
Of course. I did not want to see that be the criteria, but in fact, it was never even phrased at the trial as a, quote, economic loss
Not
rule.
specifically, but it was the same idea.
It was the idea, but had they put that label on the bottle, I think I would have objected even more loudly about making that the criteria, because that would have been clearer that we needed to go somewhere else. So
You've answered my question. Thank you.
Thank you.
Your time is up.
Good afternoon, Your Honors. Assistant Attorney General Erica Moore on behalf of the defendant appellees. This court should affirm the Superior Court's decision granting JNOV, and the first reason being that the Superior Court correctly decided that these social workers were entitled to qualified immunity because there is no clearly established law that would have put those individuals on notice. There's no authority, persuasive or controlling, and Mr. Bryan has pointed to none, which is his burden to do so, that would have put a clear signal to these social workers that their conduct violated Mr. O'Brien's property rights.
Can I ask a sort of a threshold question? Are DCF social workers actually mandated reporters?
They are mandated reporters. So the issue with this 51A, 51B, the statute says that it is required if that child is suffering from abuse or neglect. The quirky thing in this case, which is very specific to this case and why it doesn't arise in the case law very often, is that there was no allegation that this child had been abused. This arose out of the situation where Mr. O'Brien had, when they ran his background check, they got two things. They got a criminal history, which was the actual the plaintiff's. That was his personal criminal history. And that included a residency in Medford at the same time period as this DCF history. The second piece they got was the DCF history. And what came back from that was this 51A and 51B report and investigation that found that there had been prior abuse by a Robert O'Brien with a similar same age, approximate age, similar characteristics description, and Mr. O'Brien did not contest that he did not match that description.
But back to being mandated reporter.
Sure.
Yeah.
Sorry.
This was already a DCF-involved family?
It was. So
Okay. It seems kind of strange that the DCF is already on the case, that they have to file a 51A report when they're on the case already.
There could be a situation, so if there was a new allegation of abuse against the child, so the reasons that the mother and the child, not Mr. O'Brien, had an open 51A and 51B has nothing to do with this case. There was a totally separate issue. It had something to do with the custodial father, or the biological father. And so DCF, again, there wouldn't have been a reason to open a 51A in this case because there was no allegation that the child at issue here had been abused. There was a concern of this potential past history. And when DCF went to that house that day, that was the information they had. They thought that Mr. O'Brien was that individual. They had no reason to suspect he wasn't. No, Mr. O'Brien denied he was. But this idea, I want to talk a little bit about what the safety planning term. It really is just this broad term that's being applied to sort of the general work that DCF does every day working with families. They put together action plans, and those include whatever steps may be in the best interest of the child, and they work with families. That's what this safety planning is. So there's no specific safety plan, and here's the things we follow in order to
But
put that
there
together.
is with respect to everything else they do. For example, action plans and things like that, they're all part and parcel of policies that are written, whereas in the safety planning apparently was not. And of course, this is now 10 years ago, so I don't know what the current situation is, but There was the safety planning that was at issue here was not part of any official policy or written procedure of DCF at that time, correct?
In a way, the word safety planning is not used, but again, they do action plans all the time. And action plans.
The director testified in this case and said that that was the case, that the idea of safety planning was not a written protocol or procedure.
Correct. That's
Okay.
what I'm agreeing with you. I'm just saying that when they're doing these action
understood that
plans,
correctly.
those action plans may contain components that are part of a, quote, safety plan. So there is no specific document or policy that says this is a safety plan. The point I'm making is that safety planning is sort of a part of their broader goals. It's the everyday work they do with these families and what they're doing in order to take the methods.
Let me be more clear. I think that when you talk about safety planning in general, I certainly see your point. But here, safety planning referred to a specific procedure, which is have the person leave now while we investigate, right?
In this case, yes,
right.
they applied
And if
safety
the
planning.
51A had been filed instead, right, that would not necessarily have triggered this particular safety plan. Leave now while we investigate. Am I correct?
I don't believe so, because the 51A, there's case law when we're talking about, especially in the context of qualified immunity, that case law involves 51As and 51Bs, and in those cases, the agency asked a parent usually to leave the home pending an investigation. So the same conduct occurred, but they're
Okay.
arising under different circumstances.
All right, so I stand corrected. So when a 51A, at this point in time, as I said, about 10 years ago, when it would have been filed, had a 51A been filed, there would have been a request immediately before the investigation for the person to leave the household?
There could have been, yes, exactly. I mean, that's how the other case law has arisen. It's been instances
All
where.
right, so I guess I'm not asking my question. There could have been. Is it part of the protocol of a 51A that would have been filed that would have been the case?
No, it's
No.
not a specific
Case by
protocol.
case
Case by
situation.
case,
Thank
exactly,
you.
exactly, Your Honor. In any event, Mr. O'Brien has not pointed to any case law. It is not clearly established. And particularly, I want to emphasize that the cases that discuss this safety planning or this conduct of asking, in those cases, a parent to leave the home, those cases invoked, they were discussing parental rights. They were not discussing property rights. There's no case that discusses this deprivation of property rights. And that is the question that was before the jury. The jury was not asked whether or not there was a violation of 51A or 51B. They were asked about a deprivation of property rights. An objectively reasonable social worker in Mr. Russell and Ms. Dwelly's positions facing the particular circumstances they were facing would not have been on notice that their conduct was violating Mr. O'Brien's constitutional rights.
In what way? Are you talking about when they first asked him to leave or the failure to do anything about it for 4 months?
Well, there's 2 points. We have to look at the conduct specifically of Mr. Russell and Mr. Dwelly. And their conduct was at the beginning part of that question. They were involved in the decision to ask Mr. O'Brien to leave. But then after that point, after contacting Mr. O'Brien and his attorney, asking for additional information, which Mr. O'Brien did not provide, that was turned over to their supervisors. There were 2 other individuals who were the next 2 people up the chain, and they were in charge of determining what would happen at that point.
Okay, so as far as you're concerned, the issue of qualified immunity with respect to Mr. Russell and Dwelly, if I'm pronouncing it correctly.
Yes, correct.
Okay, I mean, excuse me, Mr. Kirk and
Mr. Russell and
Mr. Russell, I'm
Ms.
sorry.
Dwelly, yes.
Thank you. Is limited in your view only to that very first question.
Yes, but also I would point out that there's still no clearly established law. Even if we're talking about this whole length of period of time, this 4 months, there's no clearly established law that would have put him on notice that given the fact that they were asking for additional information, Mr. O'Brien was not providing it, and that they were unable to exclude him as that individual, there's no law that points that they should have been on notice that then deprived Mr. O'Brien of his property rights.
Was the case put to the jury solely on the ground of the constitutional right being a property interest, or was there any issue made of his right to free association?
It was solely property rights. It's in the verdict form. The Superior Court's decision should also be further upheld because no reasonable jury could have found that there was a threat, intimidation, or coercion based on the Massachusetts Civil Rights Act.
One more question on qualified immunity before you go on. Has qualified immunity doctrine been applied in the Mass Civil Rights Act context? Because I'm looking at your cases, those are all, they're all federal cases, which I assume are 1983 cases.
It applies. It applies equally to the Mass Civil Rights Act as well as, and I believe we have a case citation that says it applies to the same extent it applies to the 1983 claims.
Now economic loss.
Okay. No reasonable jury could have found that the conduct of Mr. Russell and Ms. Dwelly, which here we're talking solely Mr. Russell's statement to Mr. O'Brien that if he did not leave the home, that DCF would be required to initiate a legal consultation, which could result in the care and protection order of the child. Now, that's because this threat, intimidation, and coercion under Massachusetts law cannot be derived from the expression of intent to initiate lawful action. And here, that is precisely what Mr. Russell did. He indicated to Mr. O'Brien that DCF would have to initiate a legal consultation, which is just basically that DCF lawyers would have to get together and discuss what those next steps would be. And one of those steps could result in a care and protection order of the child. DCF was obligated to make such an assessment if Mr. O'Brien had declined to leave the home. They would have had to figure out what the next steps needed to be. I just want to be clear that that is the sole conduct. We're really talking about this one statement that Mr. Russell made to Mr. O'Brien. There's nothing else in the record, and Mr. O'Brien does not argue that anything else in the record supports that threats, intimidation, or coercion piece. And Ms. Dwelly was Mr. Russell's supervisor at that time. So in order to find her liable, it has to be based on her own conduct. And the evidence at trial for her was that she had told Mr. Russell that Mr. O'Brien needed to leave the home. There's no evidence that she instructed him any further as to the rest of what he said to Mr. O'Brien that day. Finally, I just wanted to touch, if there are no further questions on the civil rights claims, I wanted to briefly touch on the negligence verdict. First, Mr. O'Brien admits he did not offer evidence of physical injury, and we believe that he waived that argument with regard to the economic loss theory, because that was a very clear instruction to the jury, and he did not raise this in his opposition even to the JNOV at that time. In any event, the longstanding economics rule has been discussed in the context of the Massachusetts Tort Claims Act in the Allen case. Unless the court has any further questions, I would rest on our briefs.
Seeing no further questions, thank you. Thank you all for your presentation. That concludes the argument in this case and concludes our session. The panel will go back and shed our robes, and we will come back out and meet with our visitors by prior arrangement. And with that, we are adjourned.
Thank you.